Good morning to all of you. Good morning, online students. Is it audible to you? Okay, so we were in the topic of majorities. That's what we are seeing. And before majorities, we have covered the basic areas. And what is the purpose of studying about the majority? Can you just recollect why we are studying about the majorities? Because in a parliamentary democracy, most of the decisions are taken by majorities in the parliament. But different decisions to be taken require different types of majority. And who will prescribe as to what majority is required for a specific purpose? The constitution itself. But overall, if you see in the constitution only prescribes 4 types of majorities. What are the types of majorities? Simple majority, absolute majority, effective majority, and then we have got what is called a special majority. Now, within these 4 types of majorities, there is only one type of simple majority. That is only one way of calculating the simple majority. There is only one way of calculating the absolute majority. And there's only one way of calculating what is called as the effective majority. But there are different types of special majorities. So we'll try to understand for different purpose, different special majorities used. So I think this is what we have seen in the last class. So I'll proceed with the special majority, how to calculate the special majority. I'll also quickly revise about the other types of majorities. But before I proceed, do you have any questions from the previous class? We have learned about the constitution, constitutionalism, salient features, very, very important. One question you can definitely expect from salient features. It can be from parliamentary democracy, it can be from separation of powers, it can be from federal political system. Definitely one question is likely to come. And then we have understood the key terms also, which we will be repeatedly using in the class. So is there any doubt from that particular area? Yes. Not necessarily indirectly. Electoral college is a body of people. But normally for a direct election, the electoral college is too large. So we don't normally use the word electoral college. But electoral college in general means these are body of people who are eligible to vote in the elections. Okay. Any other doubt? Any other questions? If the president is issuing the ordinance, to make that ordinance permanent, the parliament has to give the approval. Within 6 weeks after they come into session. Purposefully, I did not tell all those things because we'll deal with all those things. My idea is to make you understand what is an ordinance, not to teach everything about ordinance. Ordinance is a very big topic. We can discuss about ordinance for 1 hour. So the approval has to be given by the parliament, and the time limit is 6 weeks after they come into session, for which first you'll have to understand what is session, 6 weeks from session. So I cannot give all the information because it will create a lot of doubts in your mind. So therefore, the idea is just to make you understand as to what is an ordinance. Okay. Any doubt from the online students? All right, the judiciary is given the power to interpret the Constitution of India. In fact, that is their responsibility. Under the Constitution, it is what they are supposed to do. Does it make the judiciary stronger than other 2 organs of the state? It is depending upon your subjective interpretation. So you cannot say that makes it stronger, but it is their responsibility to interpret the Constitution. And in fact, the Constituent Assembly wanted the judiciary to be independent. So therefore, the removal of the judges is also extremely difficult. So if you ask me, judiciary is more stronger than the other 2 organs, definitely not. That is not the idea in the Constituent Assembly, or that is not the idea in the Constitution. So it can be a subjective interpretation, but that is not the vision with which the Constituent Assembly has drafted the Constitution. It is a responsibility of the judiciary to interpret the Constitution because the judges are the legal experts and they are the right one to interpret the Constitution. Okay. All right. So shall we move forward to the next topic? Okay. Any question? Okay, so how did we understand as to what is a simple majority? We'll continue the topic of majorities. How many of you revised yesterday's class? Have you revised? So try to revise it on a daily basis. Not only the class number 3, you should have revised class number 1 and 2 also. So therefore it becomes easier. All right, so we'll move to the topic majority. So what is the definition of simple majority? Can you just recollect? The majority of the members present as well as voting. So what is the key information that we need to have to calculate the simple majority? We should be aware of how many are present in the house as well as voting in the house. Without this information, you will not be able to calculate. So it is nothing but the majority of the members present and voting who are voting in favor of a particular proposal. Majority of members present and voting in both the houses. Okay. So whenever I use a word in the future that this requires a simple majority, you should be able to understand what majority it requires. Majority of members present and voting. What is the next majority that we learned? Absolute majority. So come to absolute majority. What is absolute majority? Absolute majority is the majority of the total membership of the house. So the only information that we need is what? Majority of the total membership of the house. So what is the only information that we need to calculate the absolute majority? We just need to know what is the total membership of the house. We are not concerned with what is called as how many members are present and voting. So normally if you look into the constitution uses the expression majority of members present and voting. If the constitution uses the expression majority of the members present and voting, then what should be your understanding? What majority is required? Simple majority is required. If the constitution uses the expression that the majority of total membership of the house, then which majority is required? Absolute majority is required. And then there is the third majority that also we discussed yesterday is what is effective majority. So what is effective majority? It is a majority of the effective membership of the house. To put it in a very simple way, it is a majority of what? Majority of effective membership of the house. It is a majority of the effective membership of the house. And how do you calculate the effective membership? Where effective membership is equal to total membership minus what? Minus vacancies. So here the key word that you have to understand is vacancies. It is not absence, but it is about vacancies. Vacancies means that particular seat is not occupied by anyone. So the vacancy can be for any reason. So if you subtract the vacancies, then you get effective membership. And what is effective majority? A majority of the effective membership of the house. So majority of this would give us what is called as effective membership. And what is the expression that is given in the constitution? What is the expression that is given for simple majority? It is a majority of members present and voting. And what is the expression that is given in the constitution for absolute majority? The majority of the total membership of the house. And the expression that is given for effective majority in the constitution is the majority of the then members of the house. What do you understand by the then members? The then members means that the total membership minus vacancies. That is what is the then members. So if you read the constitution tomorrow, and if the constitution says, then it is the majority of the then members in the house. So what type of majority is required for the purpose? It is the effective majority. Is it clear till this point of time? And in the last class itself, I said in one instance, in a particular instance, a majority that is required is what is called as, in one instance, the effective majority is equal to that of what is called as absolute majority. So when they both are equal, when the vacancies are 0. So normally when the vacancies are 0, both the majorities are the same. Is that clear till this point of time? So now we'll move to the last type of majority is what is called as special majority. So just write down one line in your notes wherever you are making the notes. Apart from the above three types of majorities, apart from the above three types of majorities, apart from the above three types of majorities, that is simple majority, comma absolute majority, simple majority, comma absolute majority, and effective majority, all the other three types of, all the other majorities except from the, apart from the above three types of majority, that is simple majority, absolute majority and the effective majority, all the other three types of all the other majorities are classified as special majority, or classified as special majority, or classified as special majorities. However, there are different types of special majority. However, there are different types of special majority used for different purpose. However, there are different types of special majority used for different purpose. However, there are different types of special majority used for different purpose. Now, what is the understanding you should have when I say that there are different types of special majority used for different purpose? So when I say there are different types of special majority used for different purpose, that is, there are different ways of calculating the special majority. There's not just one, there's nothing, there is no unique way of calculating the special majority. So depending upon what is the proposal, there can be different types of special majority. So let us try to understand as to how the special majority is calculated with regard to amending the constitution. One place where the special majority is especially required is whenever the constitution is amended. And I have already explained with regard to the amendment to the constitution, what is the article that allows for the constitution to be amended? Very good. Article 368 allows the constitution to be amended. And who is having the authority to amend the constitution? Very good. It is a parliament which has got the authority to amend the constitution. But we also learned that it is not only under Article 368 the constitution can be amended. The constitution can also be amended outside Article 368. The constitution itself gives the details where it has to be amended under Article 368, where it can be amended outside Article 368. Whenever the constitution is amended under Article 368, what is the majority that is required? Special majority. And when the constitution is amended outside Article 368, simple majority. But we are going to discuss about the special majority where the constitution is amended under Article 368. Now, so far till this point of time, how many times the constitution has been amended? 106 times under Article 368 of the constitution. Okay, so how do we calculate the special majority? I said there are different types of special majority. Right now, the special majority that I'm going to discuss is the majority that is required to amend the constitution. Okay, so to understand the special majority as to what is required to amend the constitution under Article 368. So for your examination, you can use this expression also whenever you have to write in short form under Article 368. So when you have to amend the constitution under Article 368, before I discuss about the special majority, there are two types of amendments under Article 368. Under Article 368, again there are two types of amendments. So first let us try to understand the two types of amendments, then I'll discuss about what is the special majority that is required for this. So amendment under Article 368. So Article 368 is giving the power to the parliament to amend the constitution. I am further dividing the amendment into two types. One is amendment to the non-federal provisions of the constitution, and other is amendment to the federal provisions of the constitution. So what does it mean by amendment to the non-federal provisions and amendment to the federal provisions in the constitution? We already understood as to what is division of powers. Can you recollect? Because there is a division of powers, which is a feature in the Indian constitution, we also say that the constitution of India is a federal political system, because basically there is division of powers. So under Article 368, the parliament can amend the non-federal provisions and the parliament can amend the federal provisions also. So what does it mean by non-federal provisions? Non-federal provisions are those provisions in the constitution which is not related to the division of powers between the center and the states. That means those provisions in the constitution has nothing to do with the power division or division of powers between the center and the states, which means the implied understanding is if those provisions are amended, it is not in any way going to change the power balance between the center and the states. The status quo is going to be the same, it will maintain a status quo, though there is a change in the constitution. So can you just think me some examples of if some provision tomorrow amended in the constitution, it is no way going to increase the power of the center or reduce the power of the states or increase the power of the states vis-a-vis the center. Is there any such provision? If amended, will have no effect on the center-state relationship. To put it in a very simple way, non-federal provisions are those provisions which, if amended by the parliament, will have no effect or will have nil effect on the center-state relationship. It would continue to be the same. So that is what we'll have to understand as to non-federal provisions. Can you just give me an example of a non-federal provision if it is amended? Whatever you think. Very good. Fundamental rights. Tomorrow, if any fundamental right is taken away, or if any new fundamental right is added, it may have implications only upon the citizens' rights, but it is not going to have any impact upon the center-state relationship. The power division is going to remain the same. So any amendment to, for example, any amendment to the fundamental rights in the constitution, any amendment to the part 3 of the constitution, any amendment to the part 4 of the constitution. What is part 4? The directive principles of state policy. Any amendment to part 2 of the constitution, that is citizenship, it does not have any impact upon the center-state relationship. So such amendments are called as amendment to the federal, non-federal provisions of the constitution. So once you have understood the amendment to the non-federal provisions of the constitution, it is also easier for you to comprehend what is amendment to the federal provisions of the constitution. Now, what do you understand by amendment to the federal provisions of the constitution? Any amendment, if it is made by the parliament, will disturb the power balance between the center and the state. If it is going to alter the power balance between the center and the state, then such amendments to the constitution are called as federal provisions. It may increase the power of the center, it may decrease the power of the center, or it may increase the power of the states, or it may decrease the power of the state. In all these cases, they are considered to be amendment to what? Amendment to the federal provisions of the constitution. So can you give me an example of the amendment to the federal provisions of the constitution? Delimitation. Delimitation does not require any amendment to the constitution, which you will later understand, because delimitation is today done by a statutory body and there's nothing that is related to that in the constitution. There are few details that is given, but largely delimitation is done by the law that is made by the parliament, which I'll subsequently discuss. Have you ever heard of Schedule 7 in the constitution? Has anyone heard of Schedule 7 in the constitution? So for example, in the first class, when I talk of the federal political system, I think the second class, when I discussed about the federal political system, I also discussed that the parliament can make laws on certain areas. The state legislature can make laws on certain areas. But ultimately, who is given more power to make laws? Union. The parliament is given more power. So how do we know what are the areas on which the parliament can make laws? What are the subject matters on which the state legislature can make laws? Now, this information is given in the Schedule 7 of the Constitution. It is a Schedule 7 of the Constitution which provides the subject matters on which the parliament can make laws, subject matter on which the state legislature can make laws, subject matter on which both the parliament and the state legislature can make laws. And for your understanding, if you heard it somewhere earlier, have you ever heard that the Schedule 7 of the Constitution provides for 3 lists: union list, state list, and the concurrent list. So this union list, state list, and concurrent list all is given in the Schedule 7. It only means that there is a list which is called as union list. It has a list of items on which who can make the laws? Only the parliament can make the laws. And then there's a list of items that is given in the state list, which is also the list 2 in the Schedule 7. And who can make laws in the list 2, that is the state list? Only the state legislature. And there's also something which is called as the concurrent list. The concurrent list has got certain items on which both the parliament as well as the state legislature can make laws. So tomorrow, if the parliament makes any amendment to these areas, that they are transferring some subject matter from the state list to the union list, or they are transferring some matter from the union list to the state list, or they are transferring some subject matter from the concurrent list to the union list. In all these cases, do you think that there's a it is altering the power balance between the center and the state? Okay, now tell me, if some item is transferred from the state list to the union list, who is given more power? Union is given more power. Some item is transferred from the union list to the state list. Who is given more power? States. Some item is transferred from the concurrent list to the union list. Who is given more power? Again, union, because what is power of both of them is now given to the union alone. So anyways, it is going to disturb the power balance between the center and the state. So any amendment, for example, to the Schedule 7 of the Constitution is considered to be what? It is considered to be amendment to the federal provisions of the Constitution. So here the example is Schedule 7 in the Constitution. And you rightly said, you rightly spoke about, that's an advanced thing, that's why I didn't take it. You rightly talked about the GST, Goods and Services Tax. The Goods and Services Tax altered the financial relation between the center and the state. There is also a financial relationship between the center and the state. So GST was seen as some amount of financial powers has been taken from the states by introducing the GST. That's also an amendment to the federal provisions. So any amendment to the Constitution which is going to disturb the power balance between the center and the state, and it is not maintaining the status quo which earlier there, then such an amendment is considered to be what? Such an amendment is considered to be amendment to the federal provisions of the Constitution. Now, in both the cases, who is authority to amend, be it federal provision or be it non-federal provisions under Article 368? It is a parliament. But however, in case of non-federal provisions, it requires a separate special majority. In case of amendment to the federal provision, it requires a separate special majority. So how do you calculate the special majority is a little different. But however, in both the cases, it is called as what? Special majority. So now let us try to understand as to what is a special majority that is required. Okay, so this is the definition of federal and non-federal given there in the handout. Otherwise, you can just make a note of that alone. Before I proceed further, just make a note. What do you understand by amendment to the non-federal provision? So first write down non-federal provision. Amendment to non-federal provision. Just write down a line. Any amendment to the Constitution. Any amendment to the Constitution. Any amendment to the Constitution made by the Parliament. Any amendment to the Constitution made by the Parliament under Article 368. Under Article 368, which does not alter the power balance, between the center and the states. Which does not alter the power balance between the center and the states. Which does not alter the power balance between the center and the state. So that is a amendment to the non-federal provisions. Example, write down example. Example, any amendment to fundamental rights, directive principles of state policies, etc. In fact, most of the provisions in the Constitution are non-federal. Only few provisions in the Constitution are federal in nature. Write down amendment to the federal provisions. Second is federal provision. Any amendment to the Constitution. Any amendment to the Constitution. Any amendment to the Constitution. Any amendment to the Constitution made by the Parliament. Under Article 368. Under Article 368. Which will alter the distribution of power, between the center and the state, which will alter the power balance between, which will alter the distribution of power between the center and the state, is considered to be an amendment to the federal provisions. Is considered to be an amendment to the federal provisions. Is considered to be an amendment to the federal provisions. Example, amendment to Schedule 7 of the Constitution. Just give me a moment. Amendment to the federal provisions, amendment to the Schedule 7. And if you want more example, you can add election of president. Later you'll understand election of president, but write down the example, election of president. Now, why do you think election of president is a federal provision? Because if you see the electoral college of the president, Not only the members of the parliament or the members of the state legislature, the states are also involved in the election of the president. So therefore, in the future, if you vary all those things, you are taking away the powers of the state. So election of president, etc. There are a number of other examples. So what is the example? At least two examples I have given. One is Schedule 7 of the Constitution, election of the president. There are many more examples, but I don't want to give it right now, but later we'll be able to comprehend all those things. So this is basically what is called as amendment to the federal and non-federal provisions. Before I enter into special majority, this should be very clear in your mind. Are you clear about this? All right. So now let us try to understand the special majority. Excuse me. So now you should understand about the special majority. So there are in both the cases what is required is special majority, but the special majority is going to be little different. So now let us try to understand the special majority in case of non-federal provisions. So how do you calculate the special majority here? What the constitution says? Now don't okay, students, online students, please give me confirmation. Can you hear me? And also just update me as to what is the last thing that you heard. Okay, so which part of lecture you were hearing before the internet was disrupted? Okay, amendment to the federal provisions. I just given the notes and the example. Amendment to the federal provision. One example is Schedule 7. Then I also said election to the president, election of president. These are all examples of the federal provisions. Now we are going to understand as to how the majority is different. Although in both the cases it is called as a special majority, how the majority is different in terms of calculating for the non-federal provisions and the federal provisions. So what is a majority? So but I'm only discussing about the majority. Don't think that I'm explaining as to how a constitutional amendment is made. The process of amending the constitution is little detailed. I'll deal with that later when I take the parliament chapter. But right now I'm only discussing about what? How to calculate the special majority. Now how to calculate the special majority? So there are two important criteria that has to be satisfied. One is anyone who is introducing a proposal to amend the constitution. So to amend the constitution, first somebody has to introduce a proposal to amend the constitution, and who normally introduces this particular proposal? Any member of parliament. It is not necessary it has to be introduced only by a minister. It can be introduced by a minister or by a private member, or in other words, it can be a government bill or it can be a private member bill. So any member of parliament can introduce a bill. Now, once someone introduces the bill, they can introduce that either in the Lok Sabha or in the Rajya Sabha. So there's no restriction with regard to that in the constitution. But once a constitutional amendment bill is introduced in whichever house it is introduced, it has to be supported by not less than. So this is the first condition, not less than 2/3 of the members present and voting. It has to be supported by not less than 2/3 of the members present and voting. Minimum these many members have to support that. That is condition number one. This is not the complete condition. This is just condition number one. It has to be supported by what? Not less than 2/3 of the members present and voting. With numbers, we will be able to understand better. Okay, let us assume that we know that the bill is introduced in the Lok Sabha. Now tell me that we know that the total membership of Lok Sabha is 543. So what is the majority that is required to satisfy this? Not less than 2/3 of the members present and voting. What is the minimum number of members who has to support this constitutional amendment bill in the Lok Sabha to satisfy the first condition? Out of 543, how much has to support it? Can you calculate? No, you will not be able to calculate because the information given is insufficient. Because it is saying not less than 2/3 of the members present and voting. We are only having the total membership. We are not aware of how many members are present and voting. So let me give this detail now. So on a given day, there are 450 members who are present and voting. So irrespective of whatever is the total membership, how many members are present as well as voting on the day when the constitutional amendment bill is introduced, it is 543. Sorry, it is 450. Now tell me how many members have to support this? How many members? It is 301 or 300. Just read the statement carefully. It is not saying more than, it is only saying not less than 2/3 of the members present and voting. So therefore, how much is the minimum member? Not less than 2/3 of the members present and voting means minimum 300. It can be more than 300. 301 is also right. It can be anything more than 300 or 300 and more than 300. So it is not less than 2/3 of the members present and voting. So not less than 2/3 of the members present and voting out of 450 would be 300 and above. So minimum 300 members have to support this. So what is the minimum members? 300 members. If 300 members support this constitutional amendment bill, the first condition is satisfied. But to satisfy the special majority, it has to satisfy one more condition also. What is the next condition it has to satisfy? It should also satisfy the absolute majority of the House. It should also satisfy the absolute majority. That means the total number of members in the House who are supporting this constitutional amendment bill should also satisfy the absolute majority. That means to get the absolute majority, how many members have to minimum support this? 272 in Lok Sabha, but already 300 members are supporting. So is it satisfying the absolute majority also? Yes. Only when both the conditions are satisfied, we can say that it is passed with what is called as special majority in that particular House. Is that clear to all of you? Now you can ask me, sir, already it is 300, so why this is required? Now the example that I have taken is 450, but instead of this, let me take another example. Instead of 450 members, let us assume there are only 300 members present and voting in Lok Sabha on a given day. So what would be the first condition to satisfy the first condition? Not less than 2/3 of the members present voting. How many minimum members have to support this? 200 members. Even if 200 members supported, the first condition is satisfied. But is it satisfying the second condition? Absolute majority. It is not satisfying the second condition. So therefore, to say that a bill is passed with special majority, both the conditions has to be satisfied. What are the two conditions? Not less than 2/3 of the members present and voting, and that not less than 2/3 of members present and voting shall also satisfy the condition of what is called as absolute majority. The moment it is passed with this majority in both the houses, if the bill is introduced in the Lok Sabha, first it has to be passed with special majority in the Lok Sabha. Then it will go to the Rajya Sabha. Then it will be introduced in the Rajya Sabha. In the Rajya Sabha also, it has to be passed with the special majority. In both the houses separately, it is passed with special majority. Then it will go for the president for his assent. Then the president will give the assent. That's a different story. We're only trying to understand as to what is a special majority. Now, this is what is a special majority in case of what? Amendment to the non-federal provisions in the constitution. Is that clear to all of you? How the special majority is calculated? Now let us try to understand as to how the special majority is calculated in case of the federal provisions. Is there any doubt in the non-federal provisions? Only when you understand this, you can understand the next thing also. Is it clear till this point of time? So now let us see if a bill is introduced and that bill is trying to amend what is called as the federal provision. So what is a federal provision? That means the subject matter of that particular bill is trying to disturb the power balance between the center and the state. So in this case, what is the special majority? How do you calculate the special majority? The only difference is, so in this case also, there are two steps. First step is both condition 1 and condition 2 has to be satisfied. So both the, whatever we have seen, these things has to be satisfied. The same way in calculating the special majority. What are the two conditions that is to be satisfied? That not less than 2/3 of the members present and voting plus absolute majority. In both the houses separately it has to be passed. Suppose if it is introduced in the Lok Sabha, it has to be passed with special majority in the Lok Sabha, then goes to Rajya Sabha, then it has to be passed with special majority in the Rajya Sabha also. Then from there, in this particular case, it will go to the president, but here it will not go to the president directly. Now, once it is passed with special majority in both the houses, there's one more step before it goes to the president. It will be sent to the state legislatures. It will be sent to the state legislatures. That means presently how many state legislatures are there in our country? As many states are there. How many states are there? 28 states. So it will be sent to all the 28 state legislatures. And the state legislatures have to approve them. And how many state legislatures have to approve them? Not less than half of the state legislatures have to approve them. not less than half of the state legislatures have to approve them, or not less than half of the state legislatures have to ratify them. So what does it mean, not less than half of the state legislature? What would amount to not less than half of the state legislature out of 28 state legislature? So this is exactly the mistake that the students make. Sometimes they think not less than half means they think it is 15. It is not more than half. It is not less than half of the state legislature. That means out of 28 state legislatures, how many state legislatures have to minimum approve this, ratify this? 14 state legislatures have to approve this. Okay, tomorrow instead of 28 states, the number of states in India increases to 30, let us assume. It may vary, later we'll understand. The parliament has the power to increase or decrease the number of states in our country. Recently, the number of states has decreased. From 29, we have come to 28. But do you know what was at the commencement of the constitution? How many states were there, if you have an idea? At the commencement of the constitution? In fact, at the commencement of the constitution, the states were not numbered. They were classified as Part A, Part B, Part C, and Part D states. Now, whatever you are talking about, 14 states and 6 union territories happened only in 1956, after the first Reorganization Act. Anyways, 1956, we had 14 states and 6 union territories, and that has increased to how many states and union territories today? That has increased to 28 states and 8 union territories today. So, in the future, it can go for an alteration also. So, whatever may be the case, for this to be passed, after the special majority in both houses of the parliament, it needs to be ratified by how many states? Not less than half of the state legislature. That means the state legislature should also approve this. That means the bill will be introduced in each and every state legislature, every state legislative assembly. And if they have a council, it will be introduced in the legislative council also. If it is having only the assembly in that particular state, it has to be passed only by the assembly. But if that particular state legislature is having a legislative council, then the council should also approve that. That means they should also approve with certain majority. So they should give the approval by certain majority. And what is the majority with which the state legislatures have to give the approval? They have to give the approval with simple majority. But unless and until it is approved by not less than half of the state legislatures by simple majority, it will not go to the President of India. So when it will go to the President of India, first it has to be passed with special majority in both the houses, and then it will be sent to all the state legislatures in our country. It will be introduced in the assemblies. If the council is there also it will be introduced. Then it has to be passed with minimum 14 states. That is not less than half of the state legislatures presently, because there are 28 states. And if they are passed with simple majority in these state legislatures, how many states? Minimum, not less than half of the states. Then the bill will be forwarded to the President of India. Then the President gives the assent. Then the bill becomes an act. So this is the way that you calculate what is called as the special majority in case of amendment to the federal provisions. Now think me, the difference between the non-federal provisions and the federal provision is there's an extra step when it comes to the federal provisions. What is the extra step? That the state legislature shall also ratify. But here there is no need for the state legislature to ratify. Now, why do you think that the extra step? What is the logic behind this? Why do you think that the Constituent Assembly has put this? Because it is taking away the powers of the state, or maybe it is increasing the powers of the state. Sometimes the state does not want to have extra responsibility. Sometimes they don't want to give up their power. Either ways, when you make such changes in the constitution, you will have to respect the states, because it is affecting the interest of the state. So therefore, the state is also a stakeholder where they also need to give the ratification. But whereas in this case, the states do not have any effect, even if the amendment is passed. So therefore, the parliament can unilaterally do this. Okay, so this is what you'll have to understand. Is it clear to all of you how the special majority is calculated? But apart from this, there is a lot of other types of special majority, but I don't want to burden you with that, all those things. But I'll let you know as to whenever the respective area comes, as to how that special majority is calculated. But majorly, in most of the cases, whenever I say special majority, this is the special majority. In most of the cases, in 90% of the cases, when I say special majority, what is the implied understanding? This one. The constitution itself clearly says, but 10% of the cases, there are different types of special majority. For example, this, which also requires a ratification by the states. There are also certain other types of special majority, but we'll do that later. So right now, try to understand, to amend the Constitution of India, what is the majority that is required? Special majority. And again, we'll have to see under Article 368 whether the Constitution is amended and whether the provision that is amended is federal provision or it is non-federal provision. And depending upon whether it is a federal or a non-federal provisions, you'll have to understand as to what is the special majority and how it is to be calculated. Is it clear to all of you? So with that, we are done with the different types of majorities also, including the special majority. There are few areas where certain other types of special majority is also required. So that I'll discuss at the later stages when I take up the parliament part or the respective areas. Is it clear to all of you till this point of time as to what is simple majority, what is absolute majority, what is effective majority, and how do you calculate the special majority, especially with regard to amending the Constitution of India under Article 368. Is that clear? If that is clear, then we'll move to the next part of the discussion, that is the historical background or the historical underpinning or the constitutional history. The union territories are not in a federal relationship, so you will have to understand it is only by the states. Though the union territory might have a legislature, the union territories are not states. The union territories are only union territories. Later I will explain you why they are called as union territories. The union territories, who is the head of the union territories? Do you know who is the head of the union territories? Though they may have a legislature. For example, in Delhi they have got a legislature. Jammu and Kashmir has got a legislature. Puducherry has got a legislature. That means they also have a special status. They have a legislature, they have a chief minister and other ministers. They elected members and the government is formed. But despite all those things, you know who is the head of these union territories? Not the LG. It is a president of India under Article 239 of the Constitution. It is a president who is the head of these union executives. The LG is merely a representative of the president. The president will appoint an administrator who is called as the LG. So therefore, he is not the constitutional head. He is only representing the president. Who is the constitutional head of the union territories? It is a president. As the name suggests, union territories. Why do you know that why it is called as union territories? They are considered to be the territories of the union. That means they are under the control of the union. But whereas the states, in case of states, who is the head of the states? It is a governor. There's a separate constitutional authority that is a governor, and the president is not the head of the states, because the union and the states are in a federal relationship. There is division of power between the union and the states, but there's no division of powers between the union and the union territories, because the union territories are part of the union itself. Okay, so therefore there is no need for ratification by the union territories. But how many states have to minimum ratify? It is not less than half of the states have to ratify this. All right, so with that we'll move to the next topic. So please write down the next topic. That is a historical background. Shall I proceed to the next topic, historical background? Again, a very important topic, but please listen. If you read it from your books, you will not understand. That means you will not have that amount of clarity, because in your books, majorly the facts are given. There are a lot of interlinkages which will help you to remember most of the things. So listen to the class carefully. Okay. So please come to the next topic, that is historical background or historical underpinnings. Historical background. Shall I proceed further to the next topic? Any doubts? All right. So write down the next topic, historical background. So what this particular topic is about, historical background. This is again nothing related to the Constitution of India. But however, these historical backgrounds, or there's a lot of history behind how the Indian Constitution was drafted. Before India became independent, you all know that India was ruled by the Britishers. And how long do you think that the Britishers ruled India? Approximately for 200 years. But the association of Britishers in India is almost 350 years. Do you know when the Britishers came to India? 1600. You can put it approximately the end of 16th century or starting 17th century. That's the time that they come to India. And since the time they have landed in India, they were in India till 1947. That means almost 350 years they were there. But in the 200 years, they had political control. That means they ruled India. And for the first 150 years, they are merely traders. They're looking for the commercial benefit by having trade in India. But over a period of time, not only they are involved in trade, they also understand that there's a political vacuum in our country. There's a lot of lack of unity among the different rulers. They realize that there's a political vacuum, and that is when they try to assert their political control. And you know when they started to assert their political control in India? Very good. After the Battle of Plassey, that is when they try to assert their political control. But it was even more asserted after the Battle of Bagh, 1764, Battle of Plassey in 1757. So after that, gradually the company, the East India Company, which was the company that was established in England, and then subsequently that East India Company got rights from the British Crown to have trade with India. And that East India Company started asserting their political control over India as well. And when the East India Company was ruling India over a period of time, they brought in gradual reforms over a period of time. And those reforms, whatever they have brought in, that also influenced later the Constituent Assembly as to what kind of constitution we have today. Not only the reforms that was brought in by the East India Company, do you know that the British rule in India can be classified into two types? Majorly, it is classified into two types. One is what is called as the company rule, and then there was an era of what is called as a crown rule. There are two types of eras. Can you tell me what was the period where it was considered to be what is called as a company rule? So at what point of time the company had political control over India on behalf of the British Crown, of course. Company. From which year? 1773. From 1773 till 1857. And then that was after that it was an era of what is called as the Crown Rule. What was the era of the Crown Rule? From 1858 till 1947, when India became independent. So over these time, a lot of reforms was brought in. The Britishers tried to bring in a lot of reforms in the way that British India has to be administered. Now, whatever reforms that they have brought in has also influenced the Constitution of India. So, strictly from the point of view of what kind of constitutional developments happened is what is in this particular subject. I'll not be able to discuss the entire history. Probably all those things will be covered in your modern history. But from the point of view of Indian polity, what is my responsibility? Strictly what kind of constitutional developments have happened during this time and how they have influenced the constitution of India in the later stages. So that is what we are going to discuss here. So if you see the historical background, I can broadly classify as to the constitutional reforms or constitutional development that has happened, which later influenced the constitution of India based on two era. One is basically what is called as the company rule. Company rule, and that is from 1773 till 1857. And then there is an era of what is called as the Crown Rule. That is from 1858 to 1947. So over this time, a lot of reforms has been brought in. So we'll try to understand those reforms one by one. But before I get into this particular area, let me also brief you for 5 minutes as to what is this East India Company, because you should have an idea about this East India Company also. Now, starting 1600, as per the historian, 1600 is the year where the East India Company was established. Now, East India Company is like any company today. It's like a trading company. The East India Company which was established, and for the East India Company to be established, they got the permission through a royal charter from the Queen Elizabeth. That means they got the permission from the king or the queen at that point of time. At that time it was queen. So they have got the permission from Queen Elizabeth, and based on which this East India Company was established by some traders. And after the East India Company was established, these traders also got permission from the Queen to trade with India. They got exclusive rights to trade with India because India was considered to be very resource rich, especially in terms of spices, gold and all those things. So they got exclusive right to trade with India and certain other Southeast Asian countries. So the Britishers came to India as a part of the East India Company to have trade in India. And then they gradually established trading centers also. Say, for example, a company having branches across different parts of India. So their major branches were in three areas. They had branches in Kolkata, Bombay, and Madras. So these were the major branches that they had. And let us assume every branch will have a manager. So to manage the activities of the company. So these managers were nothing but the governors of the respective areas. So who are these governors? The governors of Bombay in East India Company, and then you have Madras and then Kolkata. So they're all like managers who are appointed by the company. And in any company, who will be the ultimate authority? If you have an idea, who will be the ultimate authority for the company? The board of directors. So who would be the board of directors in the company? The shareholders, the major stakeholders, the owners of that particular company who has put the share. So these people were called as the court of directors. So the ultimate authority for the company is the court of directors, and they appointed these managers, so who are nothing but the governors of the different trading centers. This was the initial position. And then subsequently what has happened is this East India Company was given more rights. And who are giving them rights as to how they can conduct themselves in India? Queen Elizabeth, the monarch was giving the power. So more rights were given to them. So as and when they started carrying out trade, initially they were doing only the trade activities. But later the British Crown has given them the power to engage in war with India also. And if at all they want, they can annex the territories also, if they want to annex the territories, but with one condition. If at all the if at all the East India Company will engage in war, and if they annex any new territories, the condition is that the territories will not belong to the company, but the territories will belong to the British Crown. The East India Company will merely act as a representative of the British Crown. And for that, the British Crown will also give military support to the East India Company. So on this condition, they were given the powers to annex more territories also if they can do it. So the East India Company also saw a political vacuum in India, so they also engaged in war. And one such major war that they have engaged in what is called as Battle of Plassey. Battle of Plassey in 1757. East India Company versus Nawab of Bengal. And who was the Nawab of Bengal at that point of time? Anyways, it is part of your history, just I am giving this information. Was Siraj-ud-Dowla, and he was considered to be a powerful ruler, but still he was defeated. He was defeated, I think, because of some conspiracy. His own commander was conspired with the Britishers, and subsequently, I think he lost the battle. And then they tried to assert the political control after the Battle of Plassey. But for the Britishers, the most important thing is the Battle of Bagh, which happened in 1764. Because the Britishers in 1764, that is the East India Company in 1764, has defeated the combined forces of three important rulers in India at that point of time. So who are the combined forces who are defeated at that point of time? One is the Nawab of Bengal, and the Nawab of Bengal at that point of time was Mir Qasim. Mir Qasim, and then the Nawab of Awadh, who was Shuja-ud-Dowla, and then Shah Alam, who was the Mughal emperor of India at that point of time. The combined three forces were defeated. So that allowed the Britishers, that is the East India Company, to assert even political control over India. After 1764, that is after the Battle of Buxar was over, where the combined forces were defeated, the Shah Alam, that is the Mughal emperor of India at that point of time, he has given the Diwani rights to the East India Company. Now, what do you understand by Diwani rights? So, have you learned all those things in your history? Okay, so probably you have an idea. So, I'm not going too much. Anyways, it is not my domain. So, the Diwani rights were granted, which is basically the right to collect taxes, right to collect revenues, and to carry out civil administration. So, the Diwani rights are granted. So, they now try to assert the political control, and the rulers in India were merely reduced to certain other areas. So, with this, they become so powerful, and the company started having political control, but it was not recognized completely by the British Crown. And when the Britishers, that is the East India Company, started having political control over India, the British Parliament thought that this is the time to regulate the affairs of the East India Company, because the members of the British Parliament thought that the East India Company is not administered properly. They collected revenues, but probably they're not paying enough to the British Crown, or there's a lot of corruption that is happening in East India Company. So therefore, they felt something is not good with regard to the affairs of the East India Company. So therefore, the British Parliament passed a resolution to appoint a special committee to investigate as to how the East India Company is functioning. And based on that particular inquiry, which is done by the Parliamentary Committee in British Parliament, an act was passed. And that act is what is called as the Regulating Act of 1773. Is it clear till this point of time? That means 1773, the Regulating Act of 1773 was the first step that was taken by the British Crown to regulate the affairs of what is called as the East India Company in our country. So formally, when the rule, the company rule was recognized by the British Crown, it was from the Regulating Act of 1773, majorly to regulate the affairs of the East India Company. Now, starting 1773, a number of laws was passed by the British Parliament to regulate the affairs of the East India Company, who are majorly the representatives of the British Crown with regard to the British territories in India. Alright, so it started with what? So if you see the company rule, it started with the Regulating Act of 1773. So today in class, I'll try to complete the company rule. So probably in the next class, I'll deal with what is called as the crown rule. So try to listen to me. So the Regulating Act of 1773. And then the next important act after the Regulating Act of 1773 is the Act of Settlement. Act of Settlement 1781. And then you have what is called as the Pitt's India Act. Do you know why it is called as Pitt's India Act? In fact, it was brought in by William Pitt, or he is also called as William Pitt the Young. Do you know he is the youngest prime minister in the history of United Kingdom? Maybe in the entire world also, I am not sure. Do you know what was his age when he became the prime minister of United Kingdom? What? No, he was 21 years. So he was 21 years when he became the prime minister of United Kingdom. But he has brought major reforms. He was considered to be a visionary. He brought in major reforms. Later we'll try to understand. And then there's an act of 1786. And then you had 4 charter acts. Charter Act of 1793, Charter Act of 1813, Charter Act of 1833, and the Charter Act of 1853. It is 1853. Okay. So these were the major laws that is brought in by the British Parliament to regulate the affairs of the East India Company in India. And over a period of time, a lot of changes have happened in these areas. And whatever changes that has been brought in here, that has also influenced the Constitution of India in the later stages. So that is why it becomes important for you to understand. UPSC does ask one question from this particular area in your prelims examination. Hardly any question I've asked in the mains examination, but in the last 12-13 years, one question was asked, even in the mains examination. I'll discuss that also, but not very important for your mains. If at all the question comes in the mains examination, it is likely to come from the Government of India Act 1935. We'll discuss that also, but very important for your prelims point of view. So is the background clear to all of you? So now we'll get into the Regulating Act of 1773. Shall I move forward to the Regulating Act of 1773? So what was the reason to regulate the East India Company? Why do you think that the 1773 Regulating Act was passed by the British Parliament? Company was making losses. Company on the one hand was reporting losses, but the company officials were becoming richer. They are becoming richer. In fact, do you know who are the most wealthiest persons at that point of time? The company officials. Nowhere in the world, even the companies in UK were not making much profit. But in accounts, they are showing losses, but they are becoming more richer. So they thought something is rotten with regard to the affairs of the East India Company. And that is when the British Parliament thought that the affairs of the East India Company has to be regulated. So they made changes. So they have brought in a lot to regulate the affairs of the East India Company. So now let us try to understand as to what kind of reforms has been brought in one by one. Okay, so if you see the significance of the Regulating Act of 1773, so mostly you'll have to remember certain points because factual informations might be asked from here. So I said that why the Regulating Act of 1773 was brought in. The Regulating Act of 1773 was brought in to regulate the affairs of the East India Company. One predominant trend that continued starting 1773 till the Charter Act of 1853. One predominant trend, whatever reforms that the British Parliament brought in with regard to the affairs of East India Company, is that they moved towards what is called as centralization. So each and every successive step, there was more centralization. And in fact, starting 1773, the powers were centralized in one particular authority. And the genesis of that was there in the government and the Regulating Act of 1773. Now, how did they start to centralize the power? Now, I said that what is the East India Company is just a company. And that East India Company, who is ultimate authority? The Court of Directors. But they had executive officers. Who are the executive officers who will carry out the day-to-day administration? It is the governors of different provinces. So the first thing that was done is that they tried to centralize the power in one particular authority. instead of having multiple managers, they thought that they'll have one chief executive officer. Who is the chief executive officer of the company? Who is responsible for, in general, who is the chief executive officer of a company? Who is responsible for carrying out the various, implementing the decision that is taken by the board of directors. So instead of having multiple managers, they thought that there will be one chief executive officer, and they designated who would be the chief executive officer in case of the East India Company. It is the governor of Bengal. So the governor of Bengal was redesignated as what is called as Governor General of Bengal. So till that point of time, he was only called as what? Governor of Bengal. But to make him more powerful and to make him the top executive of the company, he was redesignated as the Governor General of Bengal. Very, very important. So when was the first Governor General of Bengal was appointed? It was after the Regulating Act of 1773. And who was the first such Governor General of Bengal? It was Lord Warren Hastings. So both the information is very important. So if you see the significance is more of centralization, and they have stripped the governors of Bengal and the governors of Bombay and the governors of Madras most of their powers, and all the powers is interested in one highest officer, who is nothing but a chief executive officer of the East India Company. Although this reference is not given in the textbook, for your easy understanding, I'm saying he's like a CEO of the East India Company. And who appoints the CEO? Who will appoint the CEO? Very good. The board of directors or the court of directors. The right word is court of directors. That is what the text say. Court of directors who are nothing but the owners of the East India Company. But however, the Regulating Act brought in one more important change. It is not the absolute authority of the court of directors to appoint what is called as the Governor General of Bengal. It is subject to the approval of the British Parliament. So they may have a say in who can be appointed as what is called as the Governor General of Bengal. So this is one important change that they have brought in. So this lay down, the first significance is what? This lay down what is called as a central administration in India. So henceforth moving forward, the administration was centralized. And what was the nerve center of the British administration in India? It was Bengal. And all the executive powers are vested in the Governor General of Bengal. But try to understand that the Governor General of Bengal now has to carry out the administration of the entire East India Company. That means he is the one who is to take care of not only the commercial functions of the company, but also to take care of the political functions, the revenue collection, maintaining army and all those things. So therefore, there is also provided for a Governor General in Council. So it provided for what is called as the governor, and the governors to carry out all those things with what is called as a Governor General in Council. A 4-member Governor General in Council was also allowed by the Regulating Act. Now, what do you understand by Governor General in Council? Governor General is one person and he had 4 members. So governor along with 4 members were called as a Governor General in Council. So what is this Governor General in Council? It was basically an advisory body. But they also had some executive powers. It is similar to that of, to put it in a very simple way, it is similar to that of the Prime Minister and the Council of Ministers, if you have to relate it to the present context. So they will help the Governor General in carrying out various administration. So that was also brought in. But the ultimate authority is still vested with whom? The ultimate authority is still vested with the Governor General. He is the most powerful executive of all these people. And because he was made as a Governor General of Bengal, the governors of Bombay and Madras were subordinated to the Governor General of Bengal, because it is moving for more of what is called as centralization. So there earlier the position was equal, but now they have been subordinated to the Governor General of Bengal. And one of the important reason as to why the Regulating Act was brought in is the company was also not performing well. The company was doing losses. The company officials were engaging in a lot of corruption. So one important change that was also brought in is the company servants engaging in private trade or accepting bribes or gifts from the native people was prohibited. So it was explicitly put in the Regulating Act, which prevented the company officials from taking any gifts. So therefore, they can prevent the corruption that is happening in the country. So that has also been brought in. Okay. And it is also established what is called as a Supreme Court of India in Calcutta. So this is again very, very important. So when for the first time the Supreme Court was established? During the British rule in India, it was by the Regulating Act of 1773. And do you know what is the jurisdiction of the Supreme Court in Calcutta? Now later, after the Regulating Act of 1773, there was an act which is called as Act of Settlement. And this Act of Settlement was majorly brought in. One of the reason is that they wanted to reduce a conflict between the Supreme Court, which was established by the Regulating Act of 1773, and the powers of the Governor General in Council. So it has created some conflict, but anyways, I'll talk about the conflict. But the Supreme Court was established in Calcutta. And what was the jurisdiction of the Supreme Court at that point of time is to look into or have control over the British subjects in Kolkata. So who are the British subjects in Kolkata? The British subjects would involve those people from Britain who are staying in Kolkata at that point of time. If they have any civil dispute or if they have any of the other disputes, so who will look into all these matters? The Supreme Court of Calcutta. Not only the British subjects, it also covered the native Indians also. Not all the native Indians, but if any native Indian in Calcutta, if they have any dispute with the British subjects, if they enter into any contract with the companies, that will also fall within the jurisdiction of whom? That will also fall within the jurisdiction of the Supreme Court. And the initial act also allowed to have some element of control over the company officials also in Kolkata. So they were also under the jurisdiction of the Supreme Court. Now this led a lot of problems in the future, which I will subsequently discuss. So all those people were coming under the jurisdiction of the Supreme Court. And further, it also strengthened the control of the British government over the company, requiring the Court of Directors to report on its revenue, civil and military affairs to the India. So what does it mean? It also mandated that the Court of Directors to report to the British Crown on the various affairs of the company. So what was the role of the company at this point of time after the Regulating Act of 1773? They are performing both what is called as commercial functions as well as political function. What do you mean by commercial functions? They are trading activities. And what is their political functions? Collecting revenue from the people, maintaining the army, providing civil administration, criminal justice system. For all these cases, they have to report the matter to whom? The Court of Directors. They have to report it to the British government. That is, they have to report it to the British Crown. So therefore, you can understand overall what is the significance of all the changes that has been brought in by the Regulating Act of 1773. Is it clear to you? First and foremost significance, because sometimes they can ask questions from the inference, significance also, not directly from the provisions. The first provision is that this was the first step that was taken by the British Crown to regulate the affairs of the East India Company. So is that the first step? Yes. So they have enacted a law, so therefore they regulated the affairs of the East India Company. And they also for the first time officially recognize the political functions of the company. So do they recognize the political functions? Yes, the law allowed them to collect taxes, maintain civil administration. So all the political functions are also recognized for the first time. And most importantly, it also laid down the foundation for the central administration in our country by making Governor of Bengal as the Governor General of Bengal. Is that clear? So these are the major significance or the major changes that has happened after the Regulating Act of 1773. So let me just quickly summarize what are the major changes that has been brought in. First of all, what is the reason? I want the answer from you. So what is the major reason to enact this Regulating Act? Because they wanted to regulate the affairs of the East India Company, mainly to prevent corruption and the losses that is happening in the company. So the law was enacted, so they brought in this particular change. So they thought that the administration could be better by centralizing the administration. So how did they centralize the administration? By depriving the powers of other governors and making Governor of Bengal as the Governor General of Bengal. Who was the first such Governor General of Bengal? Lord Warren Hastings. They have not only done this, they also established what is called as a Supreme Court of India at that point of time. And the Supreme Court of India to have jurisdiction over whom? It is to have jurisdiction over the British subjects in Kolkata. It is also to have control over the company officials in certain matters, and native Indians also if they engage in contracts and any dispute with the British subjects and the company. So all those things were within the jurisdiction of the Supreme Court. And then they also brought in regulations to prevent the company officials in engaging in corruption and receiving gifts from the local people. And also they should not have any private trade as a company official. All these changes. And they also had tightened their control over the Court of Directors, asking the Court of Directors to report it to the British Crown. So all these changes has been brought in. But after the Regulating Act, so though they wanted to regulate the affairs of East India Company, after the Regulating Act, there was a dispute between the Supreme Court of India and the Governor General in Council. So what is this Governor General in Council? The Governor General in Council before the Supreme Court of India was considered to be the most powerful body when it comes to the administration in India, because it is a Governor General who is the Chief Executive Officer and he had his own Executive Council. But after the Supreme Court was established by the Regulating Act of 1773, there was some element of dispute between these two authorities. So to nullify or to remove these this particular conflict, a specific act was brought in, and that's basically what is called as Act of Settlement, or it is also called as the Amending Act of 1781. So as the name suggests, Act of Settlement. Why it is called as Act of Settlement? Basically, they wanted to settle the dispute between whom? Dispute between the Supreme Court of India and also the Governor General in Council. So basically, they had some conflict in terms of their powers. And that was brought to an end by amending the Regulating Act of 1773, and that came to be what is called as the Act of Settlement. Does anyone know what basically is the dispute between these authorities? What was the primary reason? What was the dispute? One is primarily because the Regulating Act of 1773, it was not very clear, exactly mentioned, or it was very vague as to what is the jurisdiction of the Supreme Court. So the Supreme Court tried to use wider authority. And one area where the conflict has arisen is, while the Supreme Court was there in Kolkata, but in different provinces, in the other presidencies and different provinces also, there were courts. And they were carrying out the administration of justice. After the Supreme Court came in, they started giving directions as to how the administration of justice is to be done to the other courts as well. But however, earlier before the Supreme Court, who were control of giving these directions to the other courts? It was Governor General and his council. So therefore, there was a direct conflict between the authority of the Supreme Court and the authority of the Governor General in Council. That was one conflict. Now, the second conflict is with regard to the Supreme Court of India having control over the company officials. Well, the company officials were also brought within the jurisdiction of the Supreme Court, but the Governor General in Council was not happy that the Supreme Court of India having jurisdiction over the company officials with regard to the official acts. Because with regard to the official acts, who will have control over the company officials? The Governor General in Council earlier. So now it is, now the Supreme Court has intervened. So there was a conflict with regard to this. Now the third area conflict that was addressed in the Act of 1781 is also that I also said it is not only having control over the British subjects, but also over native Indians. Native Indians in certain areas where they have conflict with the British subjects or they have conflict with the company. So the native Indians were also having issues. And what was the issue that the native Indians were having? Because they were brought within the jurisdiction of the Supreme Court. The Supreme Court was administering justice as per the English laws. But the native Indians were not happy because the native Indians were largely governing themselves based on the personal laws and the Indian system of laws. So they were not very happy about all those things. And the Governor General in Council took up all these matters with the British Crown. And subsequently, to eliminate all these conflict, the Act of Settlement or the Amending Act of 1781 was passed. And that is how the 1781 Act was brought in. For the purpose of examination, it may not be very important as it is important as the Regulating Act of 1773, but try to remember certain things, okay? So what are the major changes or what was the major objective? The major objective of this Act of Settlement is to remove the defects of the Regulating Act of 1773. And what is a major defect? The conflict between the Supreme Court and its authority versus the authority of the Governor General in Council. So basically, they wanted to remove this particular conflict. So what are the steps or what are the changes that was brought in? So the first change that was brought in is it exempted the Governor General and his executive councils and the officials of the company from the jurisdiction of the Supreme Court for their official acts. So that means for their official acts, when they are discharging their duties and responsibilities as a servant of the company, they will not fall within the jurisdiction of the Supreme Court. So they will fall within the disciplinary control of whom? They will fall within the disciplinary control of the Governor General in Council. So ultimately, who is authority with regard to the company officials for the official acts? It is only the Governor General in Council. So it restored the power back to the Governor General in Council. So this particular conflict was reduced. And then the second problem that they have addressed is that the native Indians also had problems. What is the problem with the native Indians who are falling within the jurisdiction of the Supreme Court? The native Indians are not happy because the administration of justice was done on English laws, and the English laws was something which is very new to the native Indians. So therefore they were not happy, and it affected the business interest of the company, because most of the native Indians who were having contracts with the British company and all those things, they are all big rich merchants in our country. So therefore the Governor General in Council are not happy because it may have impact upon the revenues of the company. So therefore this was also brought, and then they said that this is also not going to happen. So the Supreme Court to take into consideration the personal laws while administering justice. Okay, so that was also brought in. And then the second thing is the appeals from the provincial courts should go to the Governor General in Council. This is very, very important. I said that before the Supreme Court of India, so who are looking into giving directions with regard to the various provincial courts? Governor General in Council. And the Governor General in Council was also acting as the highest court of appeal. So subsequently, when the matters was decided by the provincial courts, the matters are coming to whom for a final decision? Governor General in Council. But after the Supreme Court started interfering in these areas. Later, the Act of Settlement put an end to this also. The Supreme Court of India will have jurisdiction only in Bengal and the British subjects in Bengal, not in the other areas. So the Governor General in Council got back their power. So appeal from the provincial courts will go to the Governor General in Council. And the Governor General in Council also to frame regulations as to how the provincial courts are to function. So the Supreme Court is not empowered to give directions in this particular regard. So all these changes has been brought in. So 4 important changes that was brought in to put an end to the dispute that brought in between the Governor General in Council and what is called as the Supreme Court of India. Is that clear to all of you? So what are the 4 major changes very quickly? First and foremost change, how the Act of Settlement was trying to resolve the dispute between Governor General in Council and the Supreme Court by basically bringing in all the company officials for their official acts within the jurisdiction of the Governor General in Council. Second dispute, the native Indians are to be administered justice if at all they fall within the jurisdiction of the Supreme Court based on the personal laws. Third important change that they have brought in is that the appeal from the provincial courts, who shall entertain those appeals? Not the Supreme Court, but the Governor General in Council. And who shall give directions and regulations as to how the provincial court shall administer justice is the Governor General in Council and not the Supreme Court. So therefore, after the amending Act of 1781, what is the jurisdiction of the Supreme Court, which was established in 1773 in Kolkata? What is their jurisdiction? One is they shall have jurisdiction over all the British subjects in Kolkata. Second is they shall have jurisdiction over the native Indians who are in conflict with the companies, but again based on the personal laws. And otherwise they do not have the other jurisdiction. So basically they restricted the jurisdiction of the Supreme Court and restored the powers of the Governor General in Council. So this is basically what has happened in the amending Act of 1781. Now the next important reform was brought in by what is called as the Pitts Act or the Pitts India Act 1784. So now let us try to understand as to what is the change that has been brought in the Pitts India Act of 1784. Shall I move forward with regard to the Pitts India Act? Any doubt till this point of time? Any doubt with regard to who is considered to be the Governor General in Council? Because most of the time students have a doubt of Governor General in Council. So I said very clearly the Governor General in Council, if you have to assume presently, is similar to that of the Prime Minister and the Council of Ministers. Assuming that the East India Company at the time was a company, but now today we have the Government of India. Okay, so it is like the Prime Minister and the Council of Ministers. So the next reform that was brought in is as far as I have researched about this, so it is said that the British subjects within Kolkata, because in the other areas they have got what is called as the provincial courts. So the provincial courts will look into all those things. So British subjects in Kolkata, in certain because basically history is an interpretation which is given by the historians. because it is not like something 1 + 1 is equal to 2. So in certain areas, I found that it is the British subjects in Kolkata. In certain areas, I have given the British subjects in Bengal, Bihar, and the other provinces, the related provinces. So you can, so anyways, UPSC may not go to that extent, or maybe you can ask that in detail to your history teacher, who will be a better person. But these two things, both are things I have come across during my readings. Okay. All right, shall I move forward? So the next thing is what is called as the Pitt's India Act of 1784. As the name suggests, this act was predominantly brought in by the British Prime Minister at that point of time, who was also called as a William Pitt the Young, because there were two prime ministers in the name of William Pitt. So to differentiate, they called this as William Pitt the Young, and it was William Pitt the Young who brought in this Pitt's India Act 1784, who was the youngest prime minister, I think 21 years when he became the prime minister. He had a very short life. I think he died in his early 30s itself. But however, he brought a lot of reforms when he was a prime minister of United Kingdom. And one important reform that he brought in, he thought that the company is still not functioning efficiently, even after the Regulating Act of 1773. So he thought how to bring in more efficiency into the company administration. And one of the reason he thought that the efficiency is less, because all the top powers are interested in the hands of the court of directors. And he thought that the court of directors should not be given all the powers. And he tried to bring in what is called as dual form of administration. So for the first time, the dual form of administration was brought in by whom? It was brought in by William Pitt through the Pitt's India Act. So this is very, very important. When the dual form of administration was brought in East India Company. I'll let you know as to what is this dual form of administration and how William Pitt was trying to bring in this dual form of administration. Okay, the first thing that I said that is he wanted to bring in more efficiency, and he thought that the court of directors, if they have all the control, the administration will not be efficient. So who are these court of directors? They are the owners of the company, the major stakeholders. And at the top, the court of directors, and below the court of directors, who is there? Governor General and his council. The Governor General and the council would execute the direction from the court of directors, and the court of directors are to report to whom? The court of directors are report to the British Crown. That is what is mandated under the Regulating Act of 1773. Now, what change has been brought in by the Pitt's India Act? So, see, this is a change that is brought in by the Pitt's India Act 1784. So, what the Pitt's India Act thought, now instead of all the powers, so ultimately at the top it is a British Crown. The British Crown, but before the British Crown, there was only court of directors. So instead of court of directors, they created two authorities under the British Crown. One is the court of directors, another is what is called as board of control. Very, very important. So they can ask you, when was the board of control created? The board of control was created by the Pitt's India Act in 1784. You have the court of directors and you have the board of control, and both can give directions. So both can give directions to the Governor General in Council. So remaining everything else is the same. The only new thing that was created by the Pitt's India Act is that they created what is called as majorly the board of control. And they have divided the responsibility between what is called as the court of directors and the board of control. So earlier it was the court of directors, the major stakeholders of the company or the owners of the company. They were responsible for everything. They were responsible for both the civil, so they were responsible for both what? They were responsible for both the commercial as well as the political functions of the company. And they were directing the Governor Generals and they are reporting to the British Crown. But now what the Pitt's India Act has done to increase the efficiency of the company, they thought that the court of directors would be responsible only for the commercial functions of the company. They will be responsible only for the commercial functions. So what do you mean by commercial functions? Only the trading related activities, nothing more than that. So you are eligible only for the commercial functions. But the board of control will be eligible for all. The board of control will be responsible for what is called as a political functions. They will be responsible for the political functions. That means they will be responsible for the revenue collection. They will be responsible for civil administration. They will be responsible for criminal administration. They will be responsible for administering the army, military. So everything is under the control of what is called as the the board of control. And the board of control will report regarding all these things to the British Crown, and they'll give directions to the Governor General of India with regard to what is called as political functions. So therefore, two hierarchy was created. One responsible for the commercial functions, another responsible for what is called as the political functions. So therefore, this is what came to be what is called as dual system of control when it comes to control over the British India. So this dual system of control was established by the Pitt's India Act. That's a major reform that has been brought in by the Pitt's India Act. By bringing in this particular reform, Pitt thought that the efficiency of the company could increase. Because otherwise he thought that the court of directors may not do the political functions effectively. So they may look only into the commercial functions. So therefore this reform was brought in. But it also had one financial implications upon the company. So what do you understand by it majorly had another financial implications? Okay, so I'll just discuss about that. But let us try to understand who are this board of control. Who are part of this board of control? Do you have any idea? Who are appointed as a part of this board of control? Majorly, to put it, instead of remembering the facts, in polity area, they may not ask this fact. I do not know how in history. But majorly, they were members of the British cabinet. They were British cabinet ministers. So some of the British cabinet ministers were made part of the board of control, and some of the higher officials in the British government, not in the East India Company, in the British government. So they were all made part of, and some of the representatives of the British Parliament was also there. So it had members from the British government, it had members from the British cabinet, and the members of the parliament. So largely they were part of the board of control, and they would report to the British Crown, and they would direct the Governor General in Council with regard to what is called as the commercial, with regard to the political functions. So this is a major change. So what is the major objective of the Pitt's India Act? So basically they wanted to distinguish between the commercial and the political functions. So this they thought would increase the efficiency of the company. And then they brought in dual system of government, where there are court of directors for commercial functions and board of control for the political. Board of control is related for will carry out civil, military, and the revenue administration. The executive council size reduced to 3 members. Okay, so there was also one more change with regard to the size of the Governor General in Council. So in the Regulating Act of 1773, what was the size of the Governor General in Council? 4, that is reduced to 3 now. So these are some of the major changes. But later you will understand this also had a financial implications upon the people of India. So how do you think it has a financial implications upon the people of India? Drain of wealth. The drain of wealth is not too much, but it has started here. But subsequently, later you'll understand the drain of wealth was more by the Charter Act of 1833. The Charter Act of 1833 resulted in complete drain of wealth. Has anyone remember what is the Charter Act of 1833 and how it resulted in the complete drain of wealth? When was the monopoly abolished? 1833 or 1813? In fact, 1833, it is not the monopoly that was abolished. 1833, it was no longer a commercial body in the first place. 1833 Charter Act made the East India Company purely a political authority. It was no longer a commercial authority. So therefore, 1833 was resulting in drain of wealth. I'll explain that. It was in 1813 the monopoly was taken away in certain areas, except to trade with trade with China and trade in tea. For the East India Company, the other monopoly was taken away. But however, the drain of wealth reached its zenith peak in the Charter Act of 1833. But this also started putting some kind of extra burden upon the Indians, the native Indians. How? Because of the things that has created, that the especially the board of control, that has created some extra burden upon the native Indians. Very good. So now they have created an extra authority, which means extra staff members, which means they'll have a lot of staff members to help them in carrying out their duties and responsibilities. Now all the salaries, their allowances, they're all to be borne by whom? They're all to be borne by the native Indians. It is not coming from the company. It has to come from where? The revenue that is to be collected, because what is their function? Their function is political functions, which includes a collection of revenue and all those things. Commercial activity, only the profit that the company makes in trade. So basically, it is to be their salaries, their allowances, all those things are to be made by the revenue that is to be collected from India. That means they started imposing more revenue over a period of time. Okay, but this is not a very big impact, but later we'll understand. In 1833, it became completely what is called as drain of wealth. All right, so we'll proceed further. The next act is the Act of 1786. Shall I move forward? The next thing, is it clear till this point of time? So what are the three major acts we have seen till this point of time? One is the Regulating Act of 1703. Then we have seen the Act of Settlement, which is basically to resolve the dispute between whom? Basically to resolve the dispute between the Supreme Court and the Governor General in Council. And then we had the Pitt's India Act, which basically brought in what is called as the dual system of government. Very, very important. Many times has been asked in the examination, which act brought in the dual system of government? It was the Pitt's India Act 1784. So now we will go to the next thing, that is Act of Settlement. Okay, so what is this Act of 1786? Act of 1786 was passed by the British Parliament to make Lord Cornwallis as the Governor General of Bengal. In fact, Lord Cornwallis was considered to be very efficient officer, that the British government wanted the British Crown wanted Lord Cornwallis to accept the governorship of Bengal, or to become the chief executive officer of the East India Company. And you know, Lord Cornwallis has brought in lot of changes. You might have read in your history as to after he became the Governor General of Bengal, he has brought in reforms in number of areas, especially I think the police system and all those things, which you might have learned in your history. I have a very remote memory of those things, because I have not read those things after I've cleared this examination. Probably as a student I have read this, but not as a teacher. But from the point of view of the constitutional history, do you know where was Lord Cornwallis before he was appointed as a governor of Bengal? He was dealing with the American Revolution, and he was so efficient, although the Britishers lost the war. But the government of the British Crown liked Lord Cornwallis, and then after the American Revolution was over, they immediately wanted Lord Cornwallis to accept the governorship of Bengal. But Lord Cornwallis did not accept with the present terms and conditions. If he is to accept the governorship of Bengal, he wanted certain changes in the act. Because ultimately you understand, the Governor General of Bengal is to govern the British India with the help of whom? The Executive Council. But Lord Cornwallis said that okay, there be a Executive Council, but with certain conditions. Only when you accept, I will accept the governorship of Bengal, that I should be the commander-in-chief of the army. Earlier, the Governor General of Bengal, the Governor General himself was not the commander-in-chief of the army. So there was certain separate authority, certain separate person. But what was the demand of Lord Cornwallis? That he himself should be the commander-in-chief of the army also, which was accepted by the British Crown, and to that extent they amended the law also. Not only he was made the commander-in-chief of the army along with the Governor General of Bengal, he also wanted veto powers over the decision that is taken by the Executive Council. So that power was also given to Lord Cornwallis. So you can understand his personality, the kind of he was very powerful in terms of what he wanted, and to that extent it was accepted. And to that extent, you can also understand that he was so efficient that the British Crown accepted to all his demands, and to that extent they have made the amendments also. That was the only major change that was brought in by the Act of 1786. The Governor General to have veto powers. What do you understand by veto powers? To reject the decision that is taken by the council. So ultimately, though the council can take a decision, whose ultimate authority to accept or not to accept? It was the Governor General. So Lord Cornwallis was having this, and the Governor General, in this case Lord Cornwallis, was also to be the Commander-in-Chief of the army, in addition to being the Governor General. And demanded by Lord Cornwallis to accept the Governor General of Bengal. So these are the major changes. Okay, just try to remember. So maybe you can remember as to that the Governor General was given veto powers, and he was also to be the commander-in-chief. So these were the major changes. And then the subsequent act was the Charter Act of 1793. So from now on, if you see the Charter Acts, the Charter Act was passed every 20 years. 1793, then 1813, then 1833, then 1853. So every 20 years, the Charter Act was passed. So what do you understand by Charter Act? Initially, the East India Company has got the rights to trade with India, the monopoly rights. So till this point of time, they are having monopoly rights to trade with India based on a royal charter. So what do you understand by charter? Royal charter. An order, a decree, which is basically issued by the British Crown. It was based on this particular charter, they got the rights to trade with India, East India Company, and subsequently at a regular period of interval, these charters were revised. And through the charter, they continued the East India Company to have the monopoly with regard to trade in India. And along with that, they also brought in certain minor reforms. So henceforth, certain minor reforms were brought in as to what the East India Company is supposed to do through these Charter Acts, which is passed by the British Parliament. So in the line of those charter, the next act was the Charter Act of 1793. What was the major objective of the Charter Act of 1793? That it extended the right of East India Company to trade with India, to have both the political as well as what is called as the commercial functions in India for the next 20 years. That means this Charter Act guaranteed that the East India Company would carry out both type of activities. So what is the activity that the East India Company can carry out? The East India Company can carry both the commercial as well as the political functions. But for commercial function, who is responsible to carry out the commercial activities in India as a part of East India Company is the Court of Directors. And for the political functions, see now whatever earlier there was carried forward. Only thing it has been extended by 20 years. So here the political control is by Board of Control. So what is the difference between Court of Directors and Board of Control in terms of their composition? Who are part of Court of Directors? The shareholders. That's not a government body, the major stakeholders. But what about the Board of Control? Government of British government. So the ministers and some MPs and probably the higher officials in the British government, they are part of the board of control. So they were allowed to do the same thing for the next 20 years. And it extended the overriding powers. What are the other changes? I said certain minimal, marginal changes have happened in relation to the previous thing. It extended the overriding power of Lord Cornwallis to all the future governor generals and the governors of other presidencies as well. So what does it mean? Whatever the power that was given to the Cornwallis, the same thing was carried forward to the other governors who were appointed. Who was the next governor general after Lord Cornwallis? If you can remember. Do you remember? John? I am not sure. I have no idea, but you can just see. So whoever is the next governor general, he was given the same power. Okay. And certain powers were given to the other presidencies also. To the other presidencies also had the governor. It is not that those posts has been removed earlier also. We only seen that they have been subordinated to the Governor General of Bengal. Okay. And I told that the 1773 Act is a starting of centralization, and that centralization continued. Do you know when the centralization reached its zenith in the entire process? 18? Now, from starting 1773 till 1853, that was an era of centralization. But starting 1858 until 1947, or if you go till 1935, because 1947 is only the independence, it did not bring in any major change. Major change as to how India is to be governed was brought in by the government of India at 1935. Now, while 1773 till 1857, it was an era of centralization. 1858 till 1835 or 1947, it was an era of decentralization. So therefore, to say that the zenith has come in 1858 is not the right thing, because then after that it was only decentralization. Because a major change in the way that the Britishers looked into India happened after the revolt of 1857. I hope you remember the revolt of 1857. So what was the major reason that the Britishers thought with regard to the revolt of 1857? They thought that one of the major failure from the part of the Britishers that led to the revolt of 1857. That took time for them to suppress the revolt of 1857. I think it took almost 2 years for the Britishers to suppress the revolt of 1857. Now, what do you think that they thought is a major reason that they are not able to suppress the revolt of 1857 immediately? Okay, so those are all some minor reasons, but majorly they thought that because of what is called as a centralized administration. And their centralized administration is one of the reasons they are not able to move their forces effectively, and it is because of their centralized administration there was a lot of revolt. They could not do good governance in India. So therefore they sought henceforth how British India is to be administered is through what is called as decentralization. So then they later on went on for decentralization. Anyways, now coming back to the Charter Act of 1793. So whatever power that was given to Cornwallis was given to the other governors also, other presidencies also. More centralized administration, as more powers were given to the Governor General of Bengal over the other governors in the presidencies. That means more and more power has been stripped from the governors, and more power is given to whom? The Governor General of Bengal. So the era of centralization continued. Okay, I did ask one more question. When did the centralization come to its zenith? 18? How in 1853? So that is because the company era is coming to an end by 1853. 1813 or 1833, 1853, I do not know. So three options here: 1813, 1833, 1853. I do not know. 1833. It is very simple because it is in 1833 the Governor of Bengal was made as the Governor General of India. That is a zenith. That is where the centralization has reached its peak. And whatever was reached in 1833 was carried forward in 1853. But 1853 does not bring in any new change with regard to centralization. It was 1833 where the centralization has reached its peak. As you might have known as easily, the Governor General of Bengal was designated as what? The Governor General of India. So it is quite easy to remember. Okay, so such type of questions can also be asked in the examination. Anyways, I'll discuss that. Board of Control, yes, they are also a specific authority. You can say that the Board of Control, there were certain ex officio members also. That means who are part of the British government. They have separate responsibility as a part of the British government. Suppose let us assume a British minister is part of the Board of Control. As a British minister, he has separate responsibility. As a part of Board of Control, his responsibility is to look into the administration of East India Company with regard to their political functions in India. Okay. Yes, East India Company. No, the British Crown will control the political functions of East India Company through the Board of Control. And the British Crown will exercise the commercial functions of the East India Company through the Court of Directors. So ultimately, who is at the top? It is the British Crown. So they have different authorities to take care of different functions and to report to the British Crown with regard to this. First charter was given way back in 1600. So it was in 1600 the East India Company was given the rights to trade with monopoly rights to trade with India. That extension not significant for you to remember. It all happened. It is only through the extension it all happened. But we cannot read each and everything that has happened in the history, right? So for us, what are the significant one which later had some kind of impact upon the Indian constitutional development? Sometimes through charter, sometimes through regulating acts. It depends upon the name of the act. Okay. Not every, it is not that every time it was 20 years. I'm not sure. But whenever the charter was given, they extended the rights of the company to carry out trade in India. First charter for the East India Company to trade with India. First charter when the East India Company was established is not important for us. Was for the first charter where the East India Company was given monopoly rights was in 1600 as per your books. Okay. Anyways, those things are not very important. You don't have to go into the facts too much. And do not make too much of research in these areas and waste. At the max, one question will come. Only certain important areas will be asked. Shall I proceed? The governors were given certain limited veto powers with regard to the functions that they are supposed to perform. In fact, the governors were deprived of their powers completely. or almost, but whatever powers they had in those areas with regard to their council, they had some veto powers. Okay, that is what. But ultimately, they did not have much powers because most of the powers were in the hands of the Governor General of Bengal. And so this is what the last thing I said. Now the Board of Control. See, in the Charter Act of 1793, when was the Board of Control established? It was established by Pitt's India Act of 1784. But in the Pitt's India Act, that the revenues to the Board of Control, they are not very clear. But now they said that the Board of Control and the staff members are to be paid from the Indian revenue, not from the company's revenue. It has to be paid from where? It is to be paid from the Indian revenue, which means it has to be paid from the taxes that is collected from the Indians. So there was an extra tax burden. So earlier it was from the trading profits, but now it is specifically mentioned who is supposed to pay. It is to be paid from the Indian revenues. That means the Indians are paying for someone who is ruling them and exploiting them. So in this way, it has been formed by the Charter Act of 1793. And this continued over a period of time. And when did the drain of wealth come to its peak? Again, I said centralization came to its peak in 1833. And when do you think that the drain of wealth came to its peak? 18? During the company rule, again it came to its peak in 1833. For the reason I'll discuss. Why in 1833? I'll discuss it. Okay, come to the next Charter Act, that is Charter Act of 1813. So Charter Act of 1813. So what is a major change that has happened in the Charter Act of 1813? It is merely an advancement of what has happened in the Charter Act of 1793. So the major thing is that again they extended the rights of the company by another 20 years. So from 1793, 1813, 20 years already it is extended. From 1813 to 1833, now they extended it. But along with that, certain other minor changes also happened. So what are the other minor changes? The minor changes is they abolished the trade monopoly, very, very important for the prelims examination. They abolished the trade monopoly. So till this point of time, the East India Company was having the monopoly trading rights with respect to India. But however, that the absolute monopoly rights was taken away, except for 2 areas, all the monopoly has been taken away. But still they continue to have monopoly in 2 areas. What are the areas still they had the monopoly rights? Trade with China and trade with tea. So these are the 2 areas they still had what is called as a monopoly rights. Okay. So other things has been taken away. Is there any specific reason as to why the monopoly? Because generally they are not happy with they having the monopoly because they are not happy with the East India Company administration over a period of time. It is because how the merchants, how the company officials were able to bargain with them, because these 2 areas were the most profitable areas. So they were not willing to give it so easily. So they tried to retain these 2 areas, trade in tea and trade with the government. The crown was not happy. So gradually they want to take away, but they had some lobby and they still continue to have both the things, which was subsequently taken away in 1833. Okay. So abolished trade in monopoly except trade open to all the merchants. So monopoly continued with in tea and in China. Very, very important. 1813, try to remember this. And apart from that, the act also asserted the undoubted sovereignty of the crown. So what does it mean? It explicitly mentioned that whatever is the East India Company and the possession of East India Company in India, it all belonged to whom? It all belonged to the British Crown, nothing to the East India Company. The East India Company can take the profits from the trade, but otherwise whatever is the possession of East India Company in India, ultimately all those belong to whom? It all belong to the British Crown. So therefore you can try to understand some element of conflict has already started between the East India Company and the British Crown. So they explicitly asserted their rights. The East India Company, sorry, the British Crown has asserted that it all belonged to the British Crown. The act also had provisions to grant permission for the activities. So this is an again important development for the Christian missionaries to come to India. So never ever the Christian missionaries were allowed to come to India. In fact, the company was against this. In fact, it was the court of directors who were against allowing the Christian missionaries to come in India and to start their missionary activities. But the 1813 Charter Act allowed the Christian missionaries to come to India and to start the missionary activities in India. Now, why do you think that the company would not be happy? The court of directors were not happy initially. So therefore, the missionary activities were not happening in India till 1813. And only in 1813 it started to happen. Of course, for the company, what is more important? For the company, it is not about the spread of religion. For the court of directors, as the owner of the company, what they wanted to have when they do trade, they wanted to have more profits. But for the court of directors, they thought that if the missionary activities are allowed, then it might be possible that the local nobles, the local rich merchants in our country might revolt. It may have an impact upon what? The business activities. And it may have an impact upon the profit. But now, ultimately, the decision is to be taken by the British Crown. So the British Parliament enacted this law, and they wanted to give equal importance to spread of the religion also. And they allowed the missionaries to come in, which the court of directors were not happy, but however, it was the will of the British Crown. So therefore, they allowed it. And majorly, they focused upon two areas. One is religion and education, these missionary activities. That is also allowed as a part of the Charter Act of 1813. So clear as to what are the major changes. But most importantly, they can ask you as to the monopoly rights it has been done with, except what? Except trade in tea and trade with China. So with these changes, another 20 years have gone. So the next is the Charter Act of 1833. So next came the Charter Act of 1833. So let us try to understand as to what happened in the Charter Act of 1833 as well. Shall we proceed further? So the next is the Charter Act of 1833. If you see the Charter Act of 1833, in the Charter Act of 1833, again the same thing. The only thing is again permission given for another 20 years. 20 years permission was given. So both they will, but one major change that has happened is, so till that point of time, till 1833, the East India Company was both a commercial body as well as a political authority. One major change that has happened in the Charter Act of 1833 is, Charter Act of 1833 reduced the East India Company purely to what is called as a political authority. It is no longer a commercial authority. So henceforth, what would be the role of the East India Company? It is only what is called as carrying out administration in India, only to collect the revenue, only to provide civil justice, and also to maintain the army. So nothing more than that. So they are no longer what is called as a company who will carry out what is called as trade. So trade was completely done away with. It mainly become an administrative body with regard to administration in our country. That means henceforth the court of directors will have no role. So who will have the role with regard to the company? It is only the board of control, but still the court of directors continue to exist. Now try to understand, it is still a company, but this company would carry out what? Only what is called as the political authorities or the political responsibility. But as a company owner, as a court of director, I want profit from the company. So that is the agreement we had. Although this Charter Act will not have a commercial function, but still as a owner, I wanted to have profit. Now you try to understand, I have a company. Now the government is saying that you do not run this company. But do you think that I'll agree to that if you say that I want to give away my commercial functions because my profit is getting affected? Now the government is making a proposal, don't worry, you don't have to run the business, but still I'll give you this much amount of money. So is it okay for the court of directors? Okay, anyways, I have no tension of running the business, but you are going to give me the revenue. You are going to compensate because I am giving away my commercial functions. So this was the agreement between the company and the court of directors and the British government, and subsequently they led to what is called as a Charter Act of 1833, because now the British Crown wanted it purely to focus on the administration. But at the same time, you don't worry, I'll give you the revenue. But from where the revenue will come from? The revenue has to come from the taxes. So that whatever is the profits that they made, even without the business, then more taxes is to be collected, and ultimately who is to bear all these increased taxes? The people of India, the native Indians have to bear. That is why I said that it has reached the zenith with regard to the drain of wealth by the Charter Act of 1833, because now the company was purely made as what? Purely made as a political authority. Is it clear? So more taxes was imposed upon the people to pay the compensation to the court of directors, to pay the salary to the company officials, and to pay the board of control and the other staff members, the entire administration with regard to all the officers and the entire civil administration, for everything from where the revenue has to come. It has to come from the taxes majorly. So therefore, this has resulted in what is called as drain of wealth in the opinion of various critics. Okay, so this is one major change that has happened. So apart from that, a lot of other changes have also happened. So the first thing is it ended the company as a commercial body. It purely became what? It purely became what is called as an administrative body. The next thing is, I said that it also is where the centralization has come to its peak. So how they brought the centralization to peak? That they have redesignated the governor of Bengal as the Governor General of India. The Governor General of Bengal as the Governor General of India. And who is first such Governor General of India? It was Lord William Bentinck. Remember this also. Both Lord Warren Hastings, Lord William Bentinck. Do not get confused. What about Lord William Bentinck? First Governor General of India. Lord Warren Hastings, first Governor General of Bengal. Okay, so this can also be asked in the prelims examination. And then because the centralization is more, so it is also depriving the powers of the other governors. Now they also deprived the law-making powers of the governors of Bombay and the Madras. So who is supposed to make law for the entire country now? It is a Governor General of India, that is Lord William Bentinck. So all the powers are given in the hands of the Governor General of India. But this is one major development that you have to understand as a part of the Charter Act of 1833. Now, the Charter Act of 1833 is significant for a number of reasons. One is, first of all, it has made the company purely what? Purely an administrative authority or purely a political authority, no longer commercial functions. Second is, it has reached the centralization. So in the company rule, if at all I say one act which is more important is the Charter Act of 1833. Many questions may come from this particular area. And in the crown rule, the most important thing is the Government of India Act 1935, which is relevant for both prelims as well as mains. So try to remember these two areas, very, very important. Okay, centralization reached its zenith. Okay, sorry, it became purely an administrative commercial, it purely become an administrative body. And then it has also reached the zenith of what is called as centralization. And this Charter Act of 1833 is also somewhere is the starting point of the present parliamentary system of government that we have got. Now, what is the basis of the parliamentary system of government? Can you just recollect from whatever discussion that you had? Then I'll try to relate how the Charter Act of 1833 is somewhere the starting point of the parliamentary system of governance. What is the basis of parliamentary democracy? Executive is accountable to the legislature. That means at least we need to have two organs. One is the legislature and the executive. Now, till this point of time, before Charter Act of 1833, now try to understand who was doing all these functions, be it lawmaking or be it the executive functions. Who is doing all those things? The Governor General in Council. It was a Governor General in Council. There was no separate legislative body. Both the functions were done by the executives only. But as long as everything is done by the executive, there is no separation of powers in the first place. Is there separation of powers? Now, what do you understand by separation of powers? There should be separate authorities entrusted with separate functions. So, in any modern democracy, at least there will be three authorities, three organs: a law-making authority, a law implementing authority, and a judicial authority to review the actions of the other two organs. But till this point of time, it was not there. So every function and every authority is entrusted upon one particular organ or one particular authority. And who is that? It was a Governor General in Council. But this is the starting point where they thought that a separate legislative body will be there. Although it is only a starting point, there was no separate legislative body per se. But now, instead of the Governor General in Council, it is called as Governor General in India Council. So this was a most powerful authority, Governor General of India in Council. That means it basically comprises of whom? It basically comprises of the Governor General of India and his council. So now, what has happened for the charter actors? It is a Governor General in Council which is still the most powerful body, which is still has to perform both the functions, both the executive functions as well as the legislative functions. But what is the difference between the earlier version of the Charter Acts and this version is, now this Governor General in Council started meeting separately. Now till this point of time, they are not meeting separately. Now the same body was only there, but they started meeting separately, or they had a different agenda. When they had a legislative agenda, they met for the legislative agenda. When they had an executive agenda, they met separately for the executive agenda. So they separately met for their legislative functions, or when they had a legislative agenda, they met separately. What do you mean by legislative agenda? Lawmaking. Lawmaking is the agenda. So for that purpose, they met separately. And similarly, when they have an executive agenda, they met separately. So when they wanted to make law, for the purpose of making law, they met separately. And when they wanted to implement certain laws, they met separately for that particular purpose. But it was the same body. There was no different bodies for different purpose. But however, today, they are not one and the same, because the legislature is different and the executive is different. Although there is some element of overlap. Can you understand that the overlap existed then also? Even today in the parliamentary system, we could see some element of overlap. So you can see to what extent we have carried forward the British legacy over a period of time. Anyways, but one difference that you have to keep in your mind, they met separately for the legislative agenda, they met separately for the executive agenda. But the important thing that you have to keep in your mind is, when they met for the legislative agenda, in addition to the Governor General Executive Council, there was one more member who was added to that. He was part of it only when they met for the legislative agenda. He was not part of the Governor General Executive Council. Who was that? A law member was there. A law member was part of that particular meeting only when the Governor General and Executive Council met for what is called as the legislative functions, and not for the other areas. Is that clear till this point of time? And who was first such a law member appointed by the British government? It was Lord Macaulay. It was Lord Macaulay who was the part of this meetings when they met for what is called as the legislative agenda. In fact, try to understand, Lord Macaulay was so significant even today in our country. And in fact, it was Lord Macaulay who was not only part of the meetings as a law member for the legislative agenda, it was Lord Macaulay who was also the first chairman of the Law Commission. Who was the first chairman of Law Commission, which was established by the Britishers? It was Lord Macaulay. So do we have law commissions today in our country? It is also there. I'll discuss it a little later. So it was Lord Macaulay, I think the name is here. It was Lord Macaulay who was also the first chairman of the Law Commission. And why Lord Macaulay is so significant today also? Do you know? Education. Okay, that is related to education. That is another significance. But Lord Macaulay is even more significant for the codification of laws. Now, one of the biggest problem for the Britishers in India is there are different laws in different provinces. Because earlier, who was making the laws? Because now you can understand, I said that it has reached the zenith of centralization. And by reaching the zenith of centralization, they also deprived the law-making powers of the provinces. And now who is supposed to make laws for the entire country? It is the Governor General in Council, and they separately met for the law-making functions. Now, earlier, there were different laws in different places. And the biggest problem is not only different laws in different places, the biggest problem is there are a lot of laws in India based on customs and personal laws. Now, you'll have to codify and you'll have to bring in some kind of uniform law throughout the country. So who was entrusted with all these responsibility? It is the Governor General Council when they met as for the legislative agenda, but who played a very prominent role in that is the law member. And who was a chairman of the Law Commission? It is the Law Commission which is to help the Governor General in Council in doing all those things when they met for the legislative agenda. And who was a chairman of the Law Commission? It was Lord Macaulay. It was Lord Macaulay who used to do all those things. A commission was appointed which was headed by Lord Macaulay to codify and to bring in uniform set of laws. to our country, and his contribution is significant even today. So, for example, it was Lord Macaulay who drafted what is called as the Indian Penal Code, which we continue to use even today. A large portion of the Indian Penal Code is what was drafted by Lord Macaulay. So, that's the contribution of Lord Macaulay with regard to the laws in our country. Okay. So, that is one thing that has significantly happened. And the next important thing is also that this 1833 Act is significant for a number of reasons, and one more reason why it is significant is also it tried to bring in what is called as open competitive system of examination to recruit the officials of the East India Company. So what was the genesis of bringing in this open competitive examination? It was a Charter Act of 1833. But although they tried to introduce, it did not materialize in the Charter Act of 1833 for the reason I'll discuss. But at least they tried to introduce open competitive system of examination in 1833. Okay, now I'll just come back to this particular area, but can anyone tell me what is the relevance of Law Commission of India today? What is the relevance of the Law Commission of India today? And what type of body it is? What type of body is the Law Commission of India? What is the function and the relevance? What is the function and the relevance of Law Commission of India? Just think about it for a moment and give me your answer. In the last class itself, I have given a hint about what type of body is Law Commission of India. Is it a constitutional body, statutory body, body established by an executive order, that is extra constitutional body? I do not know. So what type of body is the Law Commission of India? Extra constitutional. How many of you think it is extra constitutional? Extra constitutional. How many of you think it's a statutory body? The statutory body is very simple. It is established by a statute. It is established by a law. And constitutional body is established by the constitution. And when you say it is an extra constitutional body, it is established by the executive order. That is, the cabinet ministers can pass an order, or a particular ministry or a minister can pass an order, and they establish certain body that is an extra constitutional body. Now, today you should not have any doubt, the Law Commission of India is an extra constitutional body. It is what type of body? It is an extra constitutional body. It is neither mentioned in the constitution nor it is established by any statute, established by any law in India. It's an extra constitutional body. It is established by cabinet resolution, and it is under the control of which ministry in our country? Very good. It is under the control of Ministry of Law and Justice. It is under the Ministry of Law and Justice. So what is the function that they are supposed to perform? What do you think is the expected role from the Law Commission of India? See, we cannot have laws for a long period of time, because we can have, that is not an issue. But the law should always be in line with the changing social, economic, and political circumstances. You cannot make a law before 50 years and you can still continue if it becomes irrelevant to the societal changes. Now, say for example, you might understand that there is something which is called as Section 377 of IPC. Have you ever heard of the Section 377 of IPC? Has anyone heard of the Section 377? What is the Section 377 and what is the status of the Section 377 of IPC? Which is now, I think the IPC is renamed as Bharatiya Nyaya Sanhita. So whatever it is, so what is the Section 377 of IPC? Section 377 of IPC, what is Section 377? Section 377 of IPC earlier was criminalizing unnatural sex or sex against the order of nature. Unnatural sex means sex between, except the heterosexual sex, sexual orientation of people belonging to the same gender, sexual orientation with animals. So all those kind of sexes were considered to be punishable offense. But do you know what is the status of the section 377 of IPC presently? Now the section 377 of IPC has been read down by the Supreme Court. The Supreme Court, while it continued to exist, but only certain things are criminalized. Say for example, sexual orientation between same sex is not a punishable offense, as long as the sexual orientation is consensual in nature and it is between a consenting adults. Say for example, if they are homosexual, it's okay to be a homosexual as long as it is on the basis of consensus and in private. So that is what the Supreme Court of India has said, but certain things still would be punishable offense. Still sexual orientation with animals, because with animals you cannot claim that it is on the basis of consensus. So therefore it is still a punishable offense. And even if it is between same sex, but if it is a sex with minor, there you cannot consider to be a consensual sex. So that is a punishable offense. Even if it is a sex between, which is a sexual orientation between same sex on the basis of consensus between adults, but it should be in private. You cannot do that in public because it's a public nuisance. So therefore, subject to certain things, it is no longer a punishable offense. But initially, when the law was brought in, initially that was not acceptable. Today, do you think that the society is accepting same sexual orientation or sexual orientation among the same among the same gender? Largely, yes, the educated individuals, they don't have any problem as long as it is sexual orientation between consenting adults in private. Others do not have any issue. And whether you agree or you don't agree, that is the law of the land, because the Supreme Court of India has told that it should not be a punishable offense. Now, why I am discussing this is, now like this, a number of issues might come. Not every time the matter might go to the Supreme Court. Even before going to the court, the government itself can reform the laws. They themselves can amend the laws and make the changes. One way is that you go and challenge it in the Supreme Court, then the Supreme Court declare that this should not be there. Or the government itself can voluntarily look into various laws. They keep reviewing the various laws depending upon the changing value system of the society, and they can make changes to the existing laws. So who is supposed to recommend the government with regard to all those things? And who is supposed to review these laws? It is the Law Commission of India. The Law Commission of India is usually headed by whom? It is usually headed by a retired judge of a Supreme Court, and it will have other legal experts. So normally their role and function is to look into the various laws. They will see if any law has become redundant. Is there a need to make changes to some of the laws? So all those recommendations will be made by the Law Commission of India. And according to the recommendation, but the Law Commission of India is merely a recommendatory body. They're not any decision-making authority. They'll give the recommendation to the Ministry of Law and Justice, and subsequently the Ministry of Law and Justice can bring in the reforms. And subsequent to that, based on the recommendation of the Ministry of Law and Justice, the government can introduce a bill in the parliament, and then the law can be amended. So this is one way of making the changes. Now recently also I said that the government has now introduced a bill to increase the age of women up to 21 years, the marriageable age of women. That was some of the recommendation which is given by the Law Commission. So therefore the Law Commission can give a lot of recommendation, but not necessarily every recommendation is to be accepted by the government. So ultimately, who will decide whether to accept or not to accept? It is the government of India. If they accept, they'll introduce a bill and bring in the changes. That is what is a function of the Law Commission of India. Again, a very important thing. Anyways, this is part of the thing that I'll discuss in the constitutional, statutory, and the extra constitutional bodies as well. But for your idea, I have given this here itself. All right, so you try to understand this Charter Act of 1833 was significant for a number of reasons. And the other important thing is also it tried to bring in what is called as open competitive examination, but it did not materialize. Do you know why this 1833 Act, which tried to bring in open competitive examination, did not materialize? Who are majorly opposing this idea of open competitive examination? It was the Court of Directors, not the Board of Control. It is a Court of Directors. The Court of Directors still continue to exist. They also had the money from the British, the taxes that is collected from the native Indians. The Court of Directors are not willing to allow for it. Now, why do you think that the Court of Directors would oppose to this? Because if the company is more efficient, it is good for them. But they did not allow for it. because they thought that by this they would lose their patronage, because they were selling the higher post in the company to various people, especially to the rich people in the England, because it was also not only about the money. The East India Company was the highest paid company in the world at that point of time, the higher positions in East India Company. So people were willing to buy these posts for hefty money, because it was also about prestige by being part of this East India Company. So as long as it is not a merit-based system, who was controlling these recruitment and appointment? It was controlled by the court of directors, and there was a lot of nepotism, as you rightly said. They are reserving the seats for their own kith and kin, family members, relatives, and sometimes they are selling it for higher cost also, for high price also. So the complete patronage of these positions were in the hands of the court of directors. And tomorrow, if you have to bring in what is called as an open-based recruitment system, then they have to give away this particular privilege. So they are not ready to give away this particular privilege. So whatever possible, to that extent they resisted, and it never became a reality, although there was an intention to bring in this open competitive system of examination in 1833. Now this open competitive system of examination, this idea, it became a reality in Charter Act of 1853. Few years later, but it was implemented after the Charter Act of 1853. But the idea of discussing all these things, why we are discussing the entire concept of what happened during the company rule is, one is you should know, but most importantly, it is related to the topic of how it has influenced the Constitution of India. Now, do we have anything similar to this idea right now in the Indian Constitution? We have a recruiting body. We have the Union Public Service Commission and the State Public Service Commission, majorly to recruit on the basis of merit, on the basis of open competitive examination. So have we carry forward all these ideas in the Constitution of India is what we'll have to finally understand. So all these ideas have started at a very early stage, and over a period of time when the Constituent Assembly drafted, so they have carried forward these ideas, which resulted in the Constitution of India. All right, so as I already said, this has also resulted in what is called as drain of wealth. So what was the reason for the drain of wealth? The company was stripped of its commercial duties. It purely became an administrative body. So what are the various significance of the Charter Act? Very, very important. Charter Act of 1833. So 3-4 significance. Each and every point can be asked in the examination. What is the first and foremost significance? First and foremost, the company is no longer what? It is no longer a commercial body. It is purely an administrative body. And because it became a purely an administrative body, it has also resulted in what is called as drain of wealth. And the second important significance is the governor. It was reached the zenith of centralization, and how it has been more centralized than ever is the governor of Bengal. Sorry, the Governor General of Bengal was designated as the Governor General of India. And who is such first Governor General of India? Lord William Bentinck. He is not only made as the Governor General of India, but it has also deprived the legislative powers of the other provinces, of the other governors. And it is the Charter Act of 1833 for the first time made the Governor General Executive Council meet separately when they are supposed to perform the legislative functions. It was only the same council, but they met separately. They had a separate agenda, legislative agenda and the executive agenda. And when they met separately for the legislative agenda, it had one more member who was not part of the Governor General in Council. Who was that one more additional member? It was a law member. It was Lord Macaulay, who was also the chairman of the first Law Commission of the British India. And then they also tried to bring in what is called as a system of open competitive examination, which could not materialize though, because of the resistance which was given by the Court of Directors. Is it clear till this point of time? So now the major development is the Charter Act of 1853. So let's go to the Charter Act of 1853. Okay, before I go to the Charter Act of 1853, any doubt? Just look into your notes for a minute. Any doubt wherever you have, just ask me the question. Online students, you also please look at it. Explicitly, it was brought in by the Charter Act of 1813. I think Charter Act of 1813. See where they said that explicitly they said that that all the possessions of the British East India Company would belong to the British Crown. Explicitly, which was brought in, but right from 1773, it was very clear. It was clear that the East India Company is merely a representative. But if they said that when it was explicitly brought in that, it is Charter Act of 1813. Can you read out that? Okay, so that is also they are making it that it is quite clear from that particular statement. So whatever it is, it belongs to the British Crown and not to the company. So it depends upon what. So they are not going to ask you a general thing. They will put the exact phrase and then they'll ask you. So you don't have to worry about it. Okay. So can anyone explain what is drain of wealth? So he is not able to understand the concept of drain of wealth. So if you can explain, otherwise I'll explain it. Drain of wealth basically is the
Drain of wealth in what sense? The drain of wealth of the East India Company or from India?
There is no drain of wealth of the East India Company. It is the drain of wealth of the native Indians. The native Indians' wealth were taken away, and then it was given to the company officials also, and it was given to the Britishers also. So that was happening through what is called as that was a result of the Charter Act of 1833. How it has happened? Because the Charter Act of 1833 has completely made the East India Company as what? As a administrative authority. It was no longer carrying out any commercial activities. That means there was no trading activities. Earlier, trade was a major source of revenue to the company, and whatever profit that they made, that profit was used for paying the company officials. That profit was used to give some dividends and profits to the court of directors, and that profit was also used to carry out some administrative work. But now there is no commercial activities, but still all the other activities were carried out. So the company officials were engaged in administration. The salary has to be given to the company officials. The civil administration has to be carried out in India. The army has to be managed. So from all these things, where the revenue will come? The only thing is that the company is going to increase the taxes on the native Indians. Earlier, if they're paying 1 rupee tax, now they have to pay 10 rupees tax to compensate all those things. So when the people are to pay more taxes, then that is the wealth is being drained disproportionately from the Indians. So ultimately, it has resulted in what is called as drain of wealth. Okay. So that's why we have summarized that it resulted in what is called as drain of wealth. Any other doubt? Online students, any doubts? Shall we move forward? Can you be a little louder? Can we move forward? Yes. All right. So please come to the next thing, that is the Charter Act of 1853. The Charter Act of 1853 is a final act with regard to the company rule in our company rule during the British India and during the company rule. Now, the basic difference between the other Charter Act and the Charter Act of 1853, if you see the other Charter Acts before the Charter Act of 1853, they extended the life of the company by 20 years. But this is the first Charter Act which said that the company would carry out the administration on behalf of the British Crown, but without specifying a fixed time limit. So earlier they have given a fixed time limit of 20 years, but now they have not given any fixed time limit. They only said till the time the decision is taken by the Parliament, till the time the new law is enacted by the British Parliament in this regard, the company would retain its position as an commercial company would retain its position as an administrative body on behalf of what is called as a British Crown. That means this itself is a very clear indication that sooner or later the administration might be directly taken up by the British Crown. So that is one of the significance of the Charter Act of 1853, but it had certain other significance also in addition to that. So it is very clear that Charter Act of 1853, by the time itself, the British Crown was not very happy, but sooner or later they are going to take it up. But what speeded the process is the revolt of 1857. The revolt of 1857 had not happened, the company would have administered the British India for some more time, but because of the revolt of 1857, immediately they have taken up. So what are the other major changes that they brought in? One important thing that you have to definitely remember, one significance is that introduced for the first time the legislative and the executive functions of the Governor General of India in Council. Now earlier when I talked about the Charter Act of 1833, Charter Act of 1833, the Charter Act of 1833. So how it happened? Charter Act 1833. So it was the Governor General in Council, or I would put Executive Council. It was the same Executive Council. The same Executive Council met separately when it was having a legislative agenda. So for the legislative functions it met separately, and for the executive functions it met separately. This is what we have learned earlier. But now for the first time in the Charter Act of 1853, it is not that the Executive Council met separately, but the composition itself is different when they met for the legislative functions and they met for what is called as executive functions. Now earlier there was only one new member. Who was the only new member in addition to? It was only the law member. It was Lord Macaulay, the only member. But now there were additional 6 members when they met for what is called as the legislative functions. There are 6 members who are in addition, and majority of these members were representatives from the provinces, from various provinces like Madras, Bombay, and certain new provinces were also created like Agra at that point of time. So they are all representatives of these provinces. Now, why do you think that there were representatives from the provinces? Anyways, the legislative powers of the provinces are already deprived. So therefore, there were some representatives. It is not only representatives from the provinces, certain other members are also there. But you'll have to remember one thing, that these members, 6 members, when they were part of the legislative functions, they are strictly not part of the executive functions. That means when they met for the executive functions, they will not be part of it. They will be only part of what? They will be only part of the legislative functions. They have no role with regard to the executive decisions that the executive council take. The Governor General in India council takes, but they will be only part of the legislative function. So this is one major thing. So therefore, you can understand while 1833 is the rudimentary form of parliamentary democracy, which was improvised by the Charter Act of 1853. So if at all a question comes that where you can trace back to the parliamentary system of governance presently we have got, it all started in 1833, but it was further improvised in the Charter Act of 1853 by having more members. From now on, if you will see during the company rule, during the crown rule, when the crown rule has started, the crown rule has started in 1858, and subsequently after 1858, there are broadly 3 types of acts if you can bring in. One is called as the Council Acts, then you have Government of India Act, and then you have the Indian Independence Act. So can you just recollect, if you can, if you are part of the history already, history class, what are the different council acts? Indian Council Act of 1861, Indian Council Act of 1892. Very good. Indian Council Act of 1909. But do you know why they are called as council acts? Although they have came in different point of time, but they are broadly only called as the council acts. And what is the name? And what is the reason behind the council acts? Majorly, they are making changes in the legislative and the executive council. So over a period of time, they are making the legislative body more deliberative in nature. They are allowed to ask questions. They are allowed to discuss budget. They are asked to ask cross questions. They are allowed to bring in motions. So gradually, and there was some element of reform in the executive council also, but largely the reforms were there in the legislative councils. So therefore, you can understand that what has started in 1853, separate body as legislative and executive body, it kept on increasing over a period of time, and therefore it resulted in what is the kind of parliamentary democracy that we got presently. So majorly the reforms are revolving around what is called as a councils. That is why they are called as a Council Act. And then we have two Government of India Act 1919 and 1935. Why they are called as Government of India Act 1919 and 1935? Majorly they were focused upon the reforms in the administration and the kind of system that we'll have, center-state relations and all those things. So that is why they are called as the Government of India Act 1919 and 1935, not in the councils per se. It is about the overall administration in our country. And then the last thing is the Indian Independence Act. Why it is called as Indian Independence Act? Of course, it has given the independence. It has not dealt with any of the major thing. Now tell me one thing, 1947 India got independence. I'll just come back here. I'll just discuss this because I have started this. 1947 India became independent, and after the Indian Independence Act of 1947, how do you think India was governed? Okay, dominion status was given by 1947, but I am asking that once India become independent, you need to have a constitution to govern a country. You need to have a law. You cannot govern an independent country without any laws. So what was acting as a constitution of India? Because the constitution of India came into force only on 26 January 1950, but we got independence in 15th August 1947. So what was the constitution of India? How India was governed till India had its own constitution? Is it Government of India Act 1935 or the Indian Independence Act 1947? Although there was power in the hands of the Constituent Assembly to make laws, but the Constituent Assembly did not. The Constituent Assembly is already working on drafting the constitution. So therefore, they don't want to bring in any interim law before the law was the constitution is drafted. So remember, although India became independent, India was largely governed based on the Government of India Act 1935. The provisions of Government of India Act 1935 continued, based on which India was governed till the Constituent Assembly drafted the constitution, and which came into force on 26 January 1935. After 26 January 1950, then it was the Constitution of India, and then no longer the Government of India Act 1935. But try to understand, do you know that the large portion of the Indian Constitution is borrowed from where? It was from the Government of India Act 1935. So although we say that number of features has been borrowed from the various constitutions of different countries in the world, a large chunk of the Indian Constitution was taken from the Government of India Act 1935. So that is why you'll have to understand the topic of historical background, historical underpinning. And the Government of India Act 1935 itself has carried forward a number of other reforms which has happened over a period of time. So that is why this topic becomes very important, the historical background or the constitutional development. We are trying to understand gradually how all these constitutional developments are happened. Is that clear? Okay. So now coming back to the Charter Act of 1853. So it is a Charter Act of 1853 which separated the legislative and the executive functions, and there were more members when they were acting as what is called as when they are performing the legislative functions. And it was for the first time when the Governor General in Council met for performing the legislative function. It was for the first time in the history of India that they are called as what is called as the Central Legislative Council. So it is very important. So Central Legislative Council is not a separate body. It was only having whom? It was only having the Governor General in Council plus additional 6 members. But that was called as what? That was called as the Central Legislative Council, which also functioned as a mini parliament to make laws for the entire country. So that had representation from various other provinces as well, like Madras, Bombay, Bengal, Agra. So they all had the representation there. And of course, it also brought in what is called as the open competitive examination. Although it was brought in, it was implemented only after a couple of years. But this is which allowed for the open competitive examination, which failed before. That is in 1833, it failed. Okay. So these are all the major changes that has been brought in during what is called as the company rule. But what is very important is we should derive the essence of all these things. So then only it will be easier for you to remember if the question is coming from a broader topic. Say for example, sometimes a question can ask, to what extent do you think the company rule has influenced the constitution of India? So there you cannot write about each and every act. You'll have to draw the major essence out of all these acts, and then probably you should be in a position to write the answer. So what are the major inferences that you can draw from the company rule is what we are going to discuss. So these are the key points that you can carry forward from all these acts that you have seen till this point of time. One is, do you think that it has resulted in complete centralization? So throughout the course of the Company Act, it has resulted in centralization. Do you think any way it has impacted the Constitution of India? How? No, the term centralization, I'm talking about centralization. No, stronger union. We have not taken this, but rather we learned that centralization is not good. Okay, it is not that it is because of that we have gone for a strong center. So the idea is not always that what you have done. The idea is always sometimes of the learning is also what you should not do. So they learned that the centralization is not a good idea for our country. We have a history. When the Britishers ruled India through the company rule, the centralization failed. So therefore, we learned that we will not go for complete centralization. We have gone for a stronger center with states, but it is not because of this. Here we learned that we will not go for centralization. So to that extent, it has influenced the Constituent Assembly. All right. So this is one inference you can draw. And then over a period of time, you will understand that what is the major thing that has happened during the company rule is it has started from a purely commercial and administrative authority and merely it become an administrative authority. It is this administrative authority later become what is called as the Government of India. It was just the East India Company which later become, it is the missionary of East India Company today, what is the Government of India. And then this is also the genesis where there were separate executive and the legislative functions, which is also the basis of the present parliamentary system of governance. So between among all the acts that you have seen, where there was the genesis started for the parliamentary democracy, that is separate legislative and the executive function, where it all started, it was in 1833, which was further improvised in 1853. Okay. And then the next thing is, this is also the basis of the merit-based recruitment. Where is the genesis of merit-based recruitment? 1833 again. 1833 they tried to introduce, but they failed. But subsequently it became a reality when it became reality in 1853. So this is also very important. And what is a body that you have got similar to this? What is there in the present constitution? The genesis is here, but what kind of shape the constitution has for this idea? It is a Union Public Service Commission and the State Public Service Commission. And what type of body is Union Public Service Commission and the State Public Service Commission? Constitutional body. And what is the article that establishes this? It is Article 315. Very good. It is Article 315 of the Constitution that establishes that. And then we have what is called as codified laws. It is also, this era was the genesis of the codification of laws in our country. And who played a very influential role with regard to the codification of laws? It was Lord Macaulay. So all these things can be factually asked also. But I still believe that hardly any mains question can come from this particular area, because this new pattern was brought in 2012. And from 2012 to 2020, that is 2024, the last 13 years, only one question has come in the mains examination from this particular area, and that too from the Government of India Act 1935. But you never know UPSC. What is UPSC stands for? It is not only Union Public Service Commission, but it is also Unpredictable Public Service Commission. So therefore, you should be prepared. Those students who are prepared for something that the others cannot predict, their chances of succeeding is much higher. So therefore, we'll be prepared for the other areas also. But definitely, we should be prepared on those areas where UPSC has been asking. But other areas should also be prepared. So this is what is the ground rule. So we are now almost done with the ground rule. Let me just take few more minutes just to summarize what you have seen in the ground rule. So when did the crown rule for his, company rule. So crown rule is something that we'll discuss tomorrow. So when did the company rule start? It started in 1773. Now, what are the major significant things that has happened in 1773? And before that, why this regulation started is basically because the British Parliament or the British Crown was not happy with the way the company was carrying out its affairs. And they wanted to regulate this. And one major thing that they wanted to do as a part of the regulation is that they wanted to centralize the authority. And the first thing that they have done to centralize authority is they have designated the Governor of Bengal as the Governor General of Bengal. And they also thereby deprived the powers of the other governors in case of Bombay and Madras. And who was the first Governor General of Bengal? Warren Hastings was the first Governor General of Bengal. Now, subsequently, they also established what is called as the Supreme Court of India. But the biggest problem with this is they have not clearly defined the powers of the Supreme Court of India. But later that was resolved by the Act of Settlement. And the other major issue that was addressed by the Charter Act of 1773, sorry, the Regulating Act of 1773, is they also restricted the company officials from taking bribes and engaging in private trade and taking gifts from the local Indians. So these are all some of the major changes as to how they wanted to regulate the affairs of the East India Company. And this is also the first time they officially recognized East India Company to be a political authority. So political authority means an authority which is entrusted with carrying out political functions in British territory in India. And then it moved on to the next act, which is basically the Act of Settlement. What is the purpose of this Act of Settlement? The purpose of the Act of Settlement is basically to resolve the dispute that has arisen because of the establishment of Supreme Court of India. And what are the dispute? What are the areas that there were disputes? The areas where there were dispute is basically there was conflict between the jurisdiction of the Governor General Council and the authority of the Supreme Court, especially the dispute with regard to who will give directions to the provincial courts as to how they have to administer justice. And that power was restored to whom? That power was restored to the Governor General in Council, who will act as appeal from the provincial courts, who is the appellate authority. That was also restored to the Governor General in Council. And this act has also clearly said that with regard to the company officials and their official acts, the jurisdiction will be there with the Governor General in Council. And one more thing is basically the native Indians are not happy because the administration of justice in the Supreme Court was done by the English laws, and that has been now changed to the local laws. So all these major changes has been brought in by the Act of Settlement. And then subsequently the next act that was brought in was the Pitt's India Act. So what was a major change in the Pitt's India Act? That for the first time a dual system of administration was brought in. For the first time, William Pitt, by enacting this particular legislation, he brought in addition to the Court of Directors, he also brought in what is called as Board of Control. Can anyone tell me what was the responsibility of the Court of Directors and what was the responsibility of the Board of Control? Commercial functions were given to the Court of Directors and political functions were entrusted upon the Board of Control. Who is Board of Control and who is Court of Directors? Court of Directors are the owners or the major stakeholders of the company. But what about Board of Control? Board of Control, basically they are the representatives of the British government and also senior officials in the British government. So they were the Board of Control. Okay, so that was with the aim of bringing in more efficiency into the system of administration. Then the next thing is what is called as the Act of 1786. What was the major objective and reason as to why this Act of 1786 was passed? Is only to bring in Lord Cornwallis as the Governor General of Bengal. And what is the condition that he has put to become the Governor General of Bengal? Is that he should be appointed as the Commander-in-Chief of the Army, and in addition to that, he need to have veto powers over the Council. And both the things were accepted, and then subsequently he was appointed as the Governor General of Bengal. And then subsequently all the Charter Acts. So majorly the Charter Acts was trying to increase the rights that was given to the East India Company, and along with that certain reforms has also been brought in. So the first thing is the Charter Act of 1793. So what are the major changes in addition to this brought in the Charter Act of 1793? Yes, renewed to 20 years. In addition to that, what is a major change that they have brought in? Any remarkable change that they have brought in? The Charter Act of 1793. One is, yes, the salaries and the expenditures of the Board of Control is to be meted from the native Indians, so not from the company. So it is going to slightly increase the burden is one important change. What are the other changes? More power to Governor General with regard to so whatever the power that was given to the Lord Cornwallis was further subsequently given to the other Governor Generals of Bengal as well. Any significant change apart from that? You can just look into your notes and tell me. That is just basically to revise you so that it gets into your mind. And this is an area I am telling you, just go and revise it today itself. Governor General could override the count. Okay. Same as Lord Cornwallis. Any other significant thing apart from that? Salary we have already discussed. Okay, these are the major changes. Then came the Charter Act of 1813. So Charter Act of 1813, one significant change is that they have ended the monopoly except for what is called as trade in tea and trade with China. That is because again of the resistance of the court of directors. Apart from that, any major change in the okay, so they allowed the Christian missionaries to carry out the missionary activities. So till this point of time, there was no missionary activities because it was strongly resisted by the court of directors themselves. But now the British Crown was adamant that they wanted to bring in the missionaries because ultimately for the state, the larger objective is the spread of religion and their education system. And that is one of the reasons as to why the wars have happened throughout the country. So they have started this. These are the major changes. And then the Charter Act of 1833, the most important thing among all the things, and it is significant for a number of reasons. First and foremost is that it resulted in the zenith of centralization. Centralization was its peak. One is that they have redesignated the Governor General of Bengal as the Governor General of India. Who is the first such Governor General of India? Lord William Bentinck. And therefore, it also deprived the powers, the legislative powers of other governors. So it is significant for this particular reason. The second thing is, this is the first time where the Governor General in Council met separately for the legislative functions and separately for the executive function. The only exception is when they meet for the legislative function, there was one more person who was added, who was not part of the executive council. Who was that? It was a law member who happened to be Lord Macaulay. And then this is also the time where the codification of laws has started. This is also the law where they also tried to bring in what is called as open competitive system of recruitment for the East India Company, but could not materialize because of the stiff opposition from whom? From the court of directors. And then next came the Charter Act of 1853, which is significant for again couple of things. One is the Charter Act of 1853 is when they continued to meet separately for the legislative functions and the executive functions, but more number of members were there as a part of the legislative functions. How many members in addition to the executive council? 6 members were added, and for the first time when they met for the legislative function, that was referred as a Central Legislative Council. Is that clear? And the open competitive examination also become a reality. So as I already said, that after the Charter Act of 1853, we know that the Charter Act of 1853 has not given any fixed timeline. It is only till the British Parliament makes a law in this regard, the Crown, the East India Company can carry out the administration. But after the revolt of 1857, then the Crown decided that no longer the East India Company would carry out the administration, but the entire administration would be taken up directly by whom? Directly by the British Crown. Now, till this point of time, that doesn't mean they created a separate administrative structure. It is only that the company was itself taken by whom? By the British government. But one major change that has happened is, now try to understand, the revolt of 1857 has happened. They realized that the centralized administration is not going to work well. So therefore, they try to bring in certain types of reforms. And one major law that they have passed to bring in all these reforms is what is called as the Government of India Act 1858. And the Government of India Act 1858 also did not bring in any major change, but it legalized or it legitimized the transfer of power directly to the British Crown instead of what is called as an East India Company in between. So therefore, till this point of time, who are the head of the East India Company? It was a court of directors. The court of directors when it comes to the commercial function, and then the board of control. But instead of all those things, there was one British representative who is completely responsible for the administration of British India. And who is that particular authority? It was a Secretary of State, who was a cabinet minister in the British Parliament. It is a Secretary of State who is completely responsible for the British administration in India. But this Secretary of State would sit in United Kingdom. He is not locally present in India. So therefore, the Secretary of State should direct a person who will be involved in the administration in India, and he is nothing but whom? It is the Viceroy. It is nothing but the Governor General of India was renamed as what is called as Viceroy. So therefore, in your examination, if they give Governor General of India after 1858, that may also be right if the Viceroy is not there. If the Viceroy is there, what is the right answer? It is a Viceroy. So Viceroy is nothing but he is henceforth like the chief executive officer who will carry out the entire administration in India. But who has to report to whom? Who has to report to the Secretary of State, who is nothing but a cabinet minister in the British government. So this is a major change that has been brought in by the Government of India Act 1858. But after that, gradually certain councils acts was brought in, and that is the three councils act 1861, 1892 and 1909. They majorly brought in reforms in the council. And then the Government of India Act, that is 1919 and 1935, they majorly brought in reforms in the administration. And then the Indian Independence Act, which majorly brought in reforms in the, it did not bring in any reform, it just gave independence. So which we will discuss it in the next class. All right. The class is not yet over, so please write. You can close your notes, that is not an issue. So with that, we are done with what is called as the historical background with regard to what is called as the company rule. Is that clear to all of you? Which this one before this?
There was no overlap between the legislative and the
There was overlap. There was overlap. See, whoever is part of the executive council, all the executives were part of this. In addition to this, there were 6 new members. The only difference is there was only one additional member. So here there were more members. Only the composition varied. And in addition to that, there was not separately designated as a legislative council. So here for the first time, this body, when they are meeting for the legislative function, they are also referred to as Central Legislative Council. So there in 1833, it was not designated as the Central Legislative Council. But they used to sit separately, but with only one additional member. But here there were 6 new members, so the composition was enlarged. In addition to that, a new name was also given, like the Central Legislative Council. So both the changes have happened in the Charter Act of 1853. Clear? Now, before we conclude the class, so I am sure that it is clear to all of you. It is a very factual thing, so I will suggest go and read it today itself. Otherwise, most of the things you will forget. If you read it today, most of the things you will retain, and if you continuously revise it, you don't even have to read it separately in your book. You just revise from whatever you have learned in the class. That itself will be sufficient for your examination, provided you revise it. And in tomorrow, I'll continue with what is called as the crown rule, which will also take me one more class. So tomorrow fully I'll complete that. Once we are done with that, then we are ready to go to the first part of the constitution. That is, a constituent assembly is a very small topic. It will take me roughly 20-25 minutes, and then we'll go to the preamble to the Constitution of India. But even whatever I am going to discuss till the next class, you can expect 3 questions from these areas. Don't think that it is not part of the syllabus. 3 questions. You know what is the weightage of 3 questions? Not only about 6 marks. When it comes to the UPSC cutoff, when you are clearing the prelims examination, 6 marks will help you to go ahead of 10,000 candidates in the examination. So it is not just 6 marks. Don't think it like that. So with 1 mark near the cutoff, there may be around 10,000 students. So 6 marks means it will help you ahead. Whether you qualify or not qualify may depend upon these 6 marks. So don't take it very lightly. Not only for the subject polity, in every subject. This is how we'll have to score the marks. All right. So before I wind up, just a quick revision of the majorities also. Then we'll take a break. So how do you calculate the simple majority? More than 50%, majority of the members present and voting. So therefore, to calculate the simple majority, what is the only thing that you should know? The members present and voting. So how do you calculate the absolute majority? Majority of the total membership of the house. That means here you do not have to know anything about what is called as the members present and voting. The only information that you need to have is what? The only information is that the total membership of the house. And then you have what is called as effective majority. And to calculate the effective majority, what is the thing that you should know? The effective membership. You should know the effective membership. And what is the effective membership? Total membership minus vacancies. If you know that, you can calculate the effective majority. I said in one circumstances, the absolute majority and the effective majority are the same. When the vacancies are 0. Apart from these 3 types of majorities, all the other majorities are called as what is called as special majority. But however, there are different types of special majority for different purpose. We have not seen the special majority for all the purpose, But we have discussed a special majority that is required in case of a constitutional amendment. And what is the article that gives the power to the parliament to amend the constitution? Article 368. And under Article 368, we have also seen that there are two types of amendments that can happen. One is amendment to the non-federal provision, and other is an amendment to the federal provision. I want one of you to clearly explain me as to what is the difference between amendment to the federal provision and the amendment to the non-federal provision. So any representative, please think. If you make a mistake, then I'm going to extend the class by 15 minutes. So who is willing to take that particular risk? You're willing to take that risk? You're willing to take? She volunteered first, so I'll give the opportunity to her. Yes. Very good. Those amendments are going to vary the center-state relationship, and the non-federal, they don't vary the relationship between the center and the state. Can you give me an example of that? Election of president, okay. And the non-federal? Very good. Fundamental rights. Because amendment to the fundamental right is no way going to affect the center-state relationship. Amendment to the election of the president or the Schedule 7 is going to disturb the power balance. So therefore, that's a federal provision. Now coming to the question of special majority, what is a special majority in case of a non-federal provision? Can anyone tell me what is the special majority is? Not less than 2/3 of the members present and voting, plus it shall also satisfy the condition of absolute majority. When it is satisfying both the conditions, then it is passed with special majority in that particular house. Then it will be sent to the other house also. There also it has to be ratified, it has to be passed with special majority. Then it will be sent to the president for the assent. What is the special majority when it comes to amendment to the non-federal provisions? So anyways, these conditions has to be satisfied. After these conditions are satisfied, it has to be ratified by not less than half of the state legislature. Is that clear? It is only not less than half of the state legislature. In the examination, UPSC will exactly give not more than half of the state, it is more than half of the state legislature. When they say it is more than half of the state legislature, it is wrong. What is the appropriate expression given in the constitution? Not less than half of the state legislature. And what is the majority with which the state legislatures have to ratify? They have to ratify that with simple majority. In any state, if there are two houses, that is legislative assembly and legislative council, should both of them ratify it? Yes, both have to ratify. But however, later I'll explain how it will work in legislative council. But right now, try to remember, both have to ratify it. And what majority they have to ratify? They have to ratify that with simple majority. Is that clear to all of you? So please revise all those things before you come to the next class. And in the next class, we will discuss about what is called as the crown rule. And with that, the basic areas will be done, and then we'll move on to the Constituent Assembly and then the preamble to the Constitution of India. So the preamble is the preface to the Constitution. It is an introduction to the Constitution. Preamble will take me around 1 hour, and then maybe I'll start the first part of the Constitution, that is Union and its territories. So most likely in this week, till preamble will be covered. If time permits, I'll start the Union and its territories, otherwise till preamble. But even till preamble, I'll tell you how many questions. Definitely one question from the salient features. There's a possibility of one question from the constitutionalism, state, and all those things. From the keywords, there may not be any question. It is basically for your understanding. There's a possibility of one question from where? One question from the historical underpinning. Definitely one question from preamble. That means even in the first week, you may expect up to 4 questions in your preliminary examination. And that means you don't take it lightly. So these are all very, very important. From the preamble, there may be a question in your mains examination also. So if at all any mains question can come from whatever I discussed, sometimes I ask the question of whatever I've given you. I've given you one question. Can anyone read that particular question? No, the exact question. Once there was a question from that particular area. So I have given a similar question to you. Can anyone read that question? Okay, so how many of you tried writing answer to that question? All right. So I'll also verify that particular question. So one probably from that particular area, one question from the Government of India Act 1935, probably a question from the preamble. But all the 3 things are very rare chances that the question can come. But these are all the areas which is relevant for the mains. So as and when I proceed, I'll also tell you which area are relevant for the mains. I cannot tell you which area is relevant for prelims, because prelims everything is important. Everything is relevant, but certain areas are important. I'll tell the important areas. but I'll let you know which areas are relevant for the main, so that you focus on the mains area also. All right. So with that, I'll wind up the class for today. If you do not have any questions, we can wind up the class. Otherwise, if you have a question, I'll just take up the question for a couple of minutes. Excluding. So whenever you talk of the Governor General Executive Council, it is excluding the Governor General. 3 members, 4 members, it is excluding the Governor General. It is apart from the Governor General. All right. So I think with that, we can wind up the class for today, and we'll meet tomorrow. Okay. Thank you very much. And if you want to show the answers, you can show me the answers. For some, I'll do it today. For some, for 3-4 candidates, I'll do it today. For the remaining, I'll do it tomorrow.